Yo, what's up, y'all? It's Saturday, April the 4th. Welcome to another episode of Operation Wisedome. Yo, it's been a while. I know y'all out here like, what the heck is going on? Did Operation Wisedome stop? No, it ain't stop. We just had to go on a quick break as your boy had to go to the hospital. Um, yeah, we got a whole bunch going on, but we'll get into that. No worries. Don't stress. You know what I'm saying? First things first is that we're just kind of chit-chatting. And we were talking to my boy Kane, so we're gonna finish up with speaking with Kane, and then we'll get into the main, meat and potatoes of everything today. But Kane, you said now first off, you caught a case back in December, or was it January, or at least a
Uh,
charge?
December 11th was Republic and January 7th was Springfield. I got pulled over twice.
Okay, twice, and then you're currently waiting for charges to be initiated against you, right?
Yeah, no charges have been filed.
So no charges have been filed, and we're sitting at what, April the 4th?
Been 4 months
Wow.
on one and about 4 months on the other.
Okay, so are we ready to file a lawsuit or what?
That's what I'm getting ready to do.
Yeah, we're ready to file a
I,
lawsuit. Okay.
I've been studying about the last week on Title 18 and we're right in there.
Yeah, where we are.
Yep.
Did you make a preservation of evidence over to the agencies involved?
Yes, so I filed that about a month ago.
Okay, a month ago.
Yep.
And was that via mail? How'd you do it?
That I walked in there and handed it to him.
Okay, perfect, perfect. Now, Kane, you've also ended up filing notice of liabilities, correct?
Yes.
Okay, and you was able to speak with agency heads?
Yes, I actually got a meeting with the sheriff one time in Greene County.
Okay, so you've been very active in relation to your issues at hand, correct?
Oh yeah,
And do you feel as though you've built a good faith record up to this point,
absolutely.
as far as
I've
trying to get remedy on an administrative level?
yep, I've done just about everything I can do to, keep things friendly, move things forward, be as transparent as I can be, and you just get nothing from the other side.
And by having nothing on the other side, that would establish a bad faith on them, right?
Absolutely.
Okay, cool. Yeah, I wanted to check in with Kane because he's got a very interesting situation. There's just been no charges filed, and it's kind of the same situation with my boy Dan Walker. He's got kind of the same situation going on right now. He's got two different situations. The first situation is about to be dismissed. The second situation, they haven't filed anything whatsoever. So he's almost in the same situation as far as Kane is in. This episode, though, is going to be focused on two individuals that are, like, bar none, one of the most amazing people that I've ever met. I want to give a quick introduction to my boy Steve. Shout out Steve. What's up, brother? Introduce yourself real quick.
Yo, yo.
Yeah, go ahead and introduce yourself, bro. Come on, man.
Oh man, listen, man. I'm gonna go ahead and introduce myself. You know what I'm saying? I'm Steve. I DBA as Underground Rim King. I do custom wheels down here in South Florida. Yeah, you know what I'm saying? Just to give a little shout out. Boo boo. I don't know if y'all can see it,
It's a little
but that's
blurry.
the type of stuff. A little blurry. Ain't
Yeah,
no pressure. Hey, this the one that you seen when you came down here, Cam,
yeah,
on 34s.
yeah.
But nonetheless, I had needed some assistance in helping out with some court cases about a year ago, and I was like literally frustrated as hell. You know what I'm saying? Because like I had hired at that time three lawyers, paid them in full, and had to like get rid of them because I saw firsthand that they were not going to help me at all in my objectives. And I remember going online, looking for somebody on IG. I think I ran into your boy Amir, and I was like, I'm gonna go ahead and hit him up. But then I saw Cam's video, was like, bro, you are a liar. And I was like, who the hell? I was like, this dude just straight calling him out. And I said, hold on, wait a minute. He's got a phone number. You remember what man, listen, I blew Cam up, right? So it's like 9 o'clock in the morning on this side. I'm like, man, I'm beating up the phone. And and Cam hit me back. He's like, "Hey, dude. I mean, I'm on the east. I'm on the west coast, bro. It's like 6 o'clock my time, you know. But nonetheless, man, to fast forward it, I hollered at Cam. He helped me, said prepare a few little docs, and I was like, damn, bro, like I need you. I appreciate your paperwork, but I need you. And Cam said, man, fly me out, bro. You know what I'm saying? And man, so within me needing that help in about maybe like 3 weeks time, man, Cam's at the house. You know what I'm saying? In the backyard smoking a cigarette. You know what I'm saying? And we just was breaking this down. And I listen, man. I will tell you, I've been self litigating since 2009. Cam came through 2025 and gave me a gang load of gems, and how to look at things a little different. And within that, you know what I'm saying? Like I had maybe like about like 4 or 5 different things going on, and I switched my position quickly. You know what I'm saying? In those cases, I learned how to take my take my cases from trial court to DCA court. And we'll talk about this in a little bit, but that's where the real muscle is at. He was always telling me about Marcus though, because Marcus had his case going on since 2024. And I guess he introduced Marcus or gave Marcus my info and was like, hey, yo, so you need to get with this brother, so he's got a little thing going on. And me and Marcus teamed up,
Wait,
with the
wait, wait,
last.
wait, 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 wait. We'll get there. We'll get there. Not yet. Don't
Right.
tidy it up yet. Yeah.
Right.
So what's crazy about me and Steve is that I want to give you all the juice here. Steve was actually the very first person that believed in me and brought me out. Okay, I want y'all to understand that. Um, Bob was the very first donating member of Operation Wisedome, and Steve was the very first person who ever, donated and said, "Hey man, I believe in you," and come out, right? And when he brought me out, we had a very great time. Um, what's crazy is that I even had a police interaction, right? I think on Steve's
Right down the
street.
street.
On Steve's street, we saw the police pulling someone over, and I walked right up and was like, "Hey, I'm going in. Anytime I can get some police interaction and flex on the rights a little bit, I'm doing so." Steve was like, "I'm backing up, man. Don't get me hot on the block." You know what I'm saying? And it was pretty funny. And but we had a great time. We stayed up late. We stayed working. He saw firsthand how I think Sarah had her car towed or was getting
Right,
harassed by the
right, right,
police,
right, right.
and how I immediately was talking to the sheriffs or the lieutenant, making sure that she was getting her car out and she was being protected. There was a lot of action going on, and Steve was right there to see it all. And I just want to first off say to you, Steve, I really appreciate you, bro. You really someone special in my heart, brother, and I appreciate you in every single way, man, dude. Um, Secondary is Marcus. Marcus, come in. Marcus, come and introduce yourself real quick, bro.
Yeah. Um, Mark, I met Cam.
Wait, hold on. Okay, now I don't know where you got your phone connected to. If you got your phone connected to your car, um, try and just use your regular phone instead of the Bluetooth on the car because you're not coming through very clear.
Can you hear me now?
Oh yeah, that's perfect,
Clear,
bro.
loud and clear,
Way
loud and
better.
clear.
Yes, there you
Okay,
go.
hold up. Let me make sure I can hear y'all. I don't know if it's a speaker problem. Okay, hold up. This might be.
Nah, you clear.
Yeah, you
All
super
right,
clear,
all right.
bro.
All right. So, um, I had ended up catching a charge back in 2024. But before I caught that charge, I had another charge that I was out on bond for as well. Um, and I ended up catching this charge, and they revoked the bond on the other charge. So I sat in Sumter County because the charge was in Sumter County. So I sat in there for about a good 4 to 5 months, and I ran into this guy, and he was like, "Man, you need to just stop being ignorant to the law." And I kind of didn't understand what he was saying, but I ended up reading because they give us tablets in there. So I got on the tablet. I started looking up cases for that charge that I was going through. And I ended up getting them to drop all the felonies down to misdemeanors. And I just took the little misdemeanors and ran with it, did the probation while I was out on probation for this charge. And at the time, my last son from my wife, he was being about to be born like the next month. So I took the probation, came home. My son was born. Boom, boom. I got to see him. It's been 2.5 years, almost 3 years now, and I've been going back and forth to court for this case. So I got a lawyer, and I paid 12,000, and it comes all the way to the day of sentencing. Am I going to take the sentence that they're
Well,
offering?
wait. Well, just introduce yourself first off. We're gonna get into the story.
Oh, okay,
Get
okay.
into the story, but introduce yourself on like how you came about, how like you got involved with Operation Wisedome, how you met up with me.
So,
Yeah, intro,
okay, so
intro.
one day I'm online, just looking at videos, and I was watching the Brandon Joe Williams video, and I seen him and Cam. So I'm like, okay, well, who is Cam? So I ended up looking Cam up, and I see what Cam was doing. So I'm like, man, I need to get a hold of him and see, if we can, chop it up about a few things. And this was like 2 years ago, to
No,
be
it couldn't have been 2 years ago because I went
almost two
running 2
years.
years.
Almost 2 years. It's
Maybe
been
okay,
almost 2 years, Cam.
okay. So I started in November of 2024. That was when I did
24.
the first episode with Brandon Joe Williams.
Right.
But I ain't really officially start like moving and shaking and baking until February of 2025.
And I think it was around February when I got in.
Okay, cool. Yeah, probably so. Probably it was new. It was definitely fresh.
Yeah.
Okay, go ahead.
So me and Cam, we ended up, talking. I ended up doing a consultation, and Cam was like, I don't know, it feels like a little bit of property damage, and there's a crime going on here. So, it's kind of it's kind of iffy, but just give me a little bit, I'm gonna get back with you. So, I kind of stayed on Cam. I stayed on him. I stayed on him. I stayed on him. I stayed on him.
You
We
stayed
did
in the
another.
Discord too. You stayed in the
Yeah, I stayed
Discord
in the
heavy.
Discord too. Yeah,
Yeah,
heavy.
heavy.
Um, we got another consultation. Kim, you ended up setting up my page for me, my
Mm-hmm.
web page,
Mm-hmm.
and I still need to go back on there and upload some documents on there as well. But so we ended up doing the web page, and as we were doing the web page, they were taking me through the court, back and forth. So I'm stressing, I'm blowing Cam up. I know Cam's busy. He got other people to, deal with. And he's like, man, I got somebody for you, but just give me a minute. He's working on something. And then I'm gonna get back with you. So I think it was like a month went by, 2 months went by, and I ended up, I think Cam ended up hitting me up. He's like, "Hey man, I got somebody for you. He's down in Florida,
Yep.
and I'm gonna give him your number, and I'm gonna also give you his number as well. Um, and you need to call him." I said, "All right," and I was like, "Well, what did he do? Like what type of guy is he?" I'm asking. I want to know what's going on.
Yeah.
So it's like, man, he's just like you. He's going through a couple of court cases down there in Tampa area.
Okay.
So I'm like, okay, that's cool. We can probably, meet up and, chop it up. So I ended up getting Steve's number and ended up calling Steve. It went on consultation or nothing. It was just like, just call me. And we chopped it up, and bro was like, first off, we can put.
Wait. Not too deep yet. Not too deep yet.
Okay. Right.
But y'all linked up.
Yeah, we linked up. Yeah.
Okay.
So
And in the linking of you and him, how did you feel at that very moment? Or how did y'all both feel? How about that?
Oh, I'll tell you off top. I had, hey, I just probably got out of jail.
Okay.
I got arrested on something related, separate. I got a Dodge Challenger Hellcat,
Oh yeah, that's
and
right.
yeah, the police thought it was stolen. You know, so they pulled me over, did the little whatever, took me to jail. So I bonded out, got out, and that was around the time that I you connected me with Marcus, and I was like, "Yo, Marcus, man, I got court tomorrow." Marcus was like, "What? I'll be down there." You know what I'm saying? I'll come down to your court case and
Yes,
whatnot. Yeah,
because I like the experience. I like to
Yeah,
see what's going on in the courtroom.
yeah, that's love right there,
yeah,
bro. That's love right
yeah.
there.
Yeah.
So then once y'all linked up in that form or fashion, it kind of was you knew there was a tie there of mutual assistance and growth and empowerment, right?
Yes,
Okay.
definitely.
And I would have to say, just personally from my own experience, Florida is one of the worst states in relation to law enforcement and
Oh
egregious
man.
crimes against the people. I mean, literally, I feel as though it's 65 to 70% of the inquiries that I get come from Florida. But we've had major successes come out of Florida too, right? Nina B, she had 28 grams of meth, completely dismissed due to fruit of the poisonous tree. Then we had the youngster. Oh my gosh, I can't even remember his name right now. The dude with the tie sticks and the wax, white dude, really like surfer dude type vibes, youngster. He fruit of the poisonous tree from him had everything dismissed as well. And now we have Marcus and Steve coming through with some major plays, right? And all it is coming through and doing some research, understanding and looking at what the rules of the procedure are, putting those into place, right? Minds coming together and then making shit work. And that's the whole point of Operation Wisedome. Again, is it's a mastermind is not one individual that knows everything. It's a collective group of individuals that come together to make one mind. We are all here to empower each other. I am you and we are us, all a part of the great I am. And that's what we got to understand. And once you understand that, it's unstoppable. It's unstoppable. They can't stop the people. All right. So one of the things I want to first do is I kind of want to share the experience of what was happening as far as Marcus is concerned. Okay. And I guess there's no other better way than to kind of show the egregious actions, right? This is Fox 35, y'all. Can y'all see this? I need to make sure that the audio's on. Can y'all see everything here?
I can see it.
Yep.
Let me make sure I got the sound going. So we're gonna do a share. Okay, so says K9 catches man after high-speed Maserati pursuit, topping 131 miles per hour, followed by crash. Okay, this was published April 16th of 2024. Let's check and see what they had to say about my boy Marcus.
Yep.
Move this over. Look at these people. Ugh.
Deputies say, and then he.
What do we got going on here?
Not playing anymore.
I know it's tripped out. What happened? We'll do a refresh. Hold on.
I get the songs.
Look, you can even see his name right here. A 32-year-old Leesburg, Marcus Sims was arrested. Defamation of character. Why don't they want to let it load, bro? Come on. What's going on, bro? What the heck? Dang, they don't want to let it play now, bro?
You know they're gonna try to take everything down because of what's going on.
Dang, bro. They really not letting me play this right now.
Yeah, they're gonna try to take it down. That's crazy.
This is wild right now.
Can anybody else pull it up?
Hold up, let me see.
That is wild. There's no way, bro. Okay, there it goes.
There you go.
New at 10, a Maserati leads deputies on a wild chase, reaching speeds of more than 130 miles per hour. Fox 35's Kelsey Cairns is joining us live tonight from the Lake County Sheriff's Office. Kelsey, a K9 tracked down that driver. Yes, but not before.
See how they labeled the boy the driver? See how they pushed the agenda? You see
Yes.
that? You see that?
Yeah.
Got to push the narrative, right?
Before that driver actually crashed the luxury car that he was allegedly speeding in, deputies say.
And the car
and
never
then he
crashed.
attempted to run away from the scene on foot.
Are you
See how they made that
Early
too?
Sunday morning, Lake County Sheriff's deputies arresting 32-year-old Marcus Sims after he led them on a chase through Leesburg, whizzing down U.S. 27 and nearby streets. The chase starting when radar detected a driver going 106 miles per hour in a 55 zone.
He's probably in these woods.
The chase ending after deputies deployed stop strips, blowing out 3 of his tires. Sims attempting to run away on foot.
Watch out. I need a light.
Sims on the ground as a deputy canine goes in for the bite. Stuck in the brush, he tells deputies he wasn't the one behind the wheel. But deputies say it was not his homeboy. An affidavit says deputies only saw one person behind the wheel of the car during that chase.
Oh, wow. That is very extreme.
Lawton lives across the street from where Sims was arrested. He says he was asleep for the ordeal, so when Fox 35 showed him the deputy body cam, he was shocked to see something like this happen in his front yard.
Does something like this
They
happen
even showed
often
the
here?
deputy body
No,
cam?
not at all.
How
I've been
can
here
you do
since
that when there's a
2019.
trial
As
going
for
on?
Sims, once that
Even before trial.
Say that again, Papa.
How can you show any evidence before a trial or even while a trial is going on? Fox 35, we need to holler at them too, as well as A&E.
Oh yeah, they getting hollered at.
I just thought about that. I'm glad I just thought about that.
Yeah, they getting hollered at. That's for sure.
Yeah.
Yeah, ain't no doubt about it.
Oh, yeah.
that canine deputy released his grip, he was taken into custody on charges including flee to elude, resisting arrest, and driving with a suspended license, something he's been charged in the past for 6 times.
Suspended my license for a
Now,
ticket. Come on, man.
Once Sims was arrested, he bonded out of jail on $8,500 bond. He's due back in court right here on May 13th. Reporting live in Lake County tonight, I'm Kelsey Cairns, Fox 35 News.
Okay, so that's News 10.
I need to get her. I need her information too, Kelsey Karen, because you're speaking for them. You're the speaking representative for them. You push the narrative. Those words came out your mouth. I don't care what they're telling you to read off of the screen.
The one thing that stood out to me is when they says the officer or deputy's arrest affidavit says that there was only one driver in the car.
Yes.
Yeah,
That just stuck out to me.
Yeah, like they just knew. Like, how did you know? Such high speeds and such dark tint, right? It's very mysterious. But again, you got to remember they're pushing a narrative. They got to push the narrative,
Right?
Okay? They got to push the narrative. Okay. So then, what else we got? Let me see. I know I got something else that we can. I think it's this one. Yeah. Okay. So we'll bring this one over. Can y'all see this one now?
Yeah.
Okay.
Yep.
Yes,
Marcus,
yes.
you want to describe what's going on here?
Okay. So what's going on here is, and I have something also to add with that too.
Okay.
But what's going on here is this is my big cousin. He was just watching TV. You know, he be watching A&E videos all the time. That's like one of his favorite shows. When he come home from work, he do a lot of welding. So he come home and watch his little TV and have his little drink and, you know, go on about his business. But he ended up sending me this video, and I'm like, what the fuck is this? Excuse my language. Before he called me, he was like, cuz, check your phone, because I literally ain't even see that he texted me. And I'm like, what's going on? So I looked at the message, and I'm like, what's this? He like, cuz, they got a video of you out, man, on A&E. I'm like, what? So I go to watching the video. I'm like, what? And even the forensics in the video shows that the officer was biased and that his statements were misleading.
Now, let me ask you this, Marcus. How long do you think this was after the actual incident in and of itself? That it was on A&E?
It was on A&E probably like 4 months, 5 months after this.
And this is a body cam footage. You can
Matter
tell
of fact,
by
no. It wasn't even that. I was locked up in Sumter County, and it was on A&E.
No way.
Yes. So because somebody had told me that they seen me on TV, but they was in there watching A&E. You know, I kind of like stayed in my cell and was in my Bible and in the tablet reading the Constitution. I wasn't really out there with everybody out in the day room. I just separated myself from everything. But somebody told me, I'm trying to remember who told me in there, but they told me that. And I was like, what? It's kind of crazy because, you know, I give thanks to the Most High and utmost respect to him. That's how you get respect. Everybody used to come by and knock on my door before they enter my room. You know, I would give them a nod or I tell them just come in, you know. And I
I'd be
got out.
suing them for using your likeness and making a profit.
Yep.
Right.
Yep. Yep.
So we're gonna get to all that. That's what we got Cam and Steve and Joe and Jack.
Wisedome. Yeah.
You
Everybody,
know,
bro.
we
Yep.
have everybody in here. so so yeah, so my cousin he sent me the video. I'm watching the video. The video itself is forensic evidence. Okay. It shows that there is no one exiting the vehicle. Now, this is what I was talking about with my lawyer, the first lawyer I had. This is why I fired him. He told me that the video shows my face clearly jumping out of this car. This is why I want him too, as well. Yeah, because he told me he deleted the footage for this case with the last case because I had him for the Sumter County case. I got out on probation with him and did the probation while fighting this case. He lied to me, so I fired him and I told him that I wanted to see the video. He called me back 3 days later and said that he's sorry and that he had a misunderstanding that the video doesn't show me getting out the car, doesn't even show me near the car. So I fired him. I went and hired another lawyer and he wouldn't go by the Constitution because he had an oath. That struck something in my head. Like, dang, if I tell you to file this, it goes against your oath. So you can't do that because your duty is to the court first.
Mm.
I'm like, wow. So I'm like, man, that reprogrammed me back to Cam. That's when I still coming back. I'm hitting you up, Cam. I'm blowing you up. Like, Cam, who do you got for me? I'm not really telling you what's going on at this point, but I'm asking, who do you got for me and who is it? And that's when you linked me in with Steve. But let me put this in there too, out there. During the time that I got out of Sumter County on probation and still fighting these charges, the officers in this case, they have pulled me over multiple times, harassed me. They ripped the door handle, the door panels off inside the car, thinking that it's something in the door. I got videos of it. I never stated nothing about this, but they continuously, tremendously harassed me, pulled me over, searched me, violated my Fourth Amendment. They had no warrant. They found no narcotics in the car. I had my marijuana. Of course, I had my card for it. So they had to let me go on that. Not only just the city and county where I caught the case at, they flagged me. They flagged the car. So every agency that pulled me over, I want them as well. Every time I go to Orlando, an officer, he almost caused a wreck to get behind me and pull me over because the car is known.
Yeah, I remember
That
you had told me that.
situation. Yes.
Now remember,
Now,
you made a very good statement as well, though, that I just want to bring to the forefront, and it's on the screen. Okay, let's read this. An attorney has a duty to aid in the administration of justice, aid the court in avoiding error, and in determining a
yes,
cause in accordance with justice and the rules of practice, uphold the legal process, and uphold the authority and dignity of the courts.
of
The
course.
attorney's duty to the court is superior to the attorney's duty to a client.
So a client.
Okay.
That is crazy.
I want y'all to really understand what's going on here. Okay. When Marcus speaks of, I had an attorney, I had to fire him, and whoop 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 whoop. This is real talk. When the attorney lies and misquotes and makes a misstatement of saying, oh well, I saw you getting out of the car. Like,
Yes.
what is that? That's a coercion. That's a
Yeah.
coercion for Marcus to feel a certain way, to feel distressed, to feel anxiety, to feel
Yes.
depression. And in that, What is that? That's irreparable harm. Okay. So the depths of damages that have been done to Marcus across the board, not only to people that he's paying, okay, to people that he's paying, but also to those who have an agenda to make him seem as though he is a criminal. All right. As though he is someone who is just outrageous and whatever the case may be, whatever picture that they're painting. Right. And this is what we're combating, right? Is that until there's a corpus delicti or someone with a verified complaint, okay, or at least the agencies have at least a warrant of some sort, there needs to be true actual harm that's been done. A warrantless arrest is serious, okay? There must be a true crime of harm being done to another that the law enforcement, supposed colorable law enforcement, has seen. Okay. I want to let this play real quick just so everybody can see what happened on A&E from that perspective. Is that cool?
That's fine.
All right, let me cue
also the video I sent you, you can let that play as well if you want.
Okay.
That's fine.
He keeps going, traveling at speeds as high as 113 miles an hour. It looks like these two deputies have the suspect pinned on a residential street, but the driver makes a quick move around this pickup truck onto the sidewalk and speeds away. Eventually, the suspect wrecks out and flees on foot. Deputies arrive at the crash site and set up a perimeter.
So what we're noticing is that when they pull up to the Maserati, no, they don't see anybody jump out the car.
They don't see anybody jump out.
Nobody.
There's nobody jumping out the car, is there?
No, nobody.
Okay, I want y'all to unmute and y'all tell me from your perspective. Let's watch it now. I'll even take the volume down so that everybody can answer. Let's see.
FYI, you got the original video too, Cam.
Oh, is it in my?
Yes.
Okay, so this is A&E, y'all. All right, so this is A&E. So let me stop sharing because I don't want everybody up in my personal business like that for a second. So if I go Marcus, scroll up. I don't know if this is the original one though. That's the original A&E. You talking about the original A&E one?
No, I sent you the video without the A&E, the original dash cam of the officers.
Let me see. I ain't never deleted none of our texts. They go all the way back to March 18th.
Let me see.
I'm serious too. Let me see if I can minimize this.
Did I send it on?
Here, I'll show you. This is what I got. I'm about to show you share screen because I was able to minimize my text. So let's see, sure. So if you see
I sent it
March 18th.
Facebook.
Look at Joe. March 18th. But look, March 18th, 2025. Here's the first call. That's what's up.
Yep. It's on Facebook. I sent it to you on Facebook.
On Facebook? Oh shit!
Yes.
I gotta stop sharing.
Messages.
It's in the messenger on Facebook.
Yeah.
Okay, hold on. Let me check.
That's the video of that officer. He stated he saw a black male jump out the driver's seat and run westbound. Never had a description. Never stated what the.
I think I got it. I think I got it, Papa. I just don't know if I can forward or download. Okay, let me download it. And then I can maybe like zoom in type vibes. Just don't know how to zoom in on the quick player. Okay, so let's. I'm not sharing screen yet. No, where's the meeting? Oh, it's right there. Sorry, I'm all over the place. I got two screens, but I'm trying to operate it.
All right. I'm actually, while we're doing this, I'm gonna actually email you like two more videos. One with the key in the back seat because they did the vehicle impound sheet, right? On the vehicle impound sheet, it stated that there was nothing in the back seat or on the back seat floor. But I
Okay.
have the video of the officer going in the back seat, getting the key off the back seat floor.
Hmm.
I got a quick question for you. When they took stuff from your vehicle, did they give you a receipt or any kind of inventory list?
No, not that I know of. There's money
Yeah,
missing.
they're
Uh,
supposed to give you an inventory list of everything they take in an inventory search.
right.
And that's supposed to be within a certain timeline, depending on your state.
Yeah, they ain't give me that. That was money.
Yeah.
That was like over $5 grand missing.
Yeah,
It's
I
just
just
in
want
my
everyone to
pocket.
know. Everyone
Yeah.
who's here, if you're ever in an inventory stop and they arrest you, they need to be giving you.
Damn, I wish I could zoom in on this
I
thing, man.
think they're supposed by arraignment. You're supposed to have
There it
that.
goes. Yes. Okay, cool. Now I got it. All right.
But that seems like that's what they do down here in Florida anyway. They did the same thing with me when they took my car. I ain't get no inventory.
So what is this before they pulled you over or what?
No, I'm finna send that to you on the laptop. I'm gonna
Well,
send
what
it.
is this? What is this one here? Because there ain't no lights on or nothing.
Right. So this is the officer who stated that he saw me jump out and run as he approached the vehicle. Now let's see if by his statement that he made to the arresting officer was true.
They ain't got no lights on or nothing either. That's wild.
Nothing. Now on the A&E video, the first truck that you see pull up behind the vehicle is that one in front of him.
Right. Yeah, I could tell the one in front was another cop.
Right. Now, you see brake lights. He's about 1,000 feet away. How can you see anybody jump out the vehicle and run? You don't see nothing. He's over 1,000 feet away from the vehicle.
Oh man. Oh yeah. There's nobody. There's
Yeah,
nobody
you
that they
see
can see that
that?
got out and ran. Oh.
He said he saw me
Oh
jump out and
yeah.
run westbound. Hey,
Oh,
what?
that's a total lie, bro.
Wow.
So let's come back a little bit because okay, so right here we got both doors closed, right?
Both doors are
Right.
closed.
And y'all can unmute and answer if y'all want. There's quite a few of y'all in here. Collectively, as a group, do we see that both doors are closed on this vehicle?
Yes, all doors are closed.
Yes. Cool. Yes.
I want some more answers. I mean, I got people muted up. Y'all can unmute and answer, please. When we are pulling up to this vehicle, do we see that all doors are closed, y'all?
Yeah, they're closed. They look closed to me.
Yes, sir. Yes, sir.
Yes.
I also see there's no independent light over there.
There is no independent
Right.
light. It's completely dark.
And the cops about to cause a wreck.
Hold on. So just real quick, just to give some context, the arrest affidavit says at 2 times the vehicle was seen going over 106 miles an hour. The second one, officer said over 131 miles an hour. It is roughly about 3 o'clock in the morning. This is an all black Maserati with all black tinted windows. And they stated in the affidavit that they saw one occupant driving. And that was also in the news clipping where the lady says arrest affidavit or
Yep.
officer's affidavit states that there was only one driver.
Yep. Good job, Steve.
Yep.
So was there more than one person in the car? If we can lock down this little wooded lot right here at the corner of Castine and
I
that
was
curve,
intoxicated in the back
he's probably
seat.
in these woods.
All right, so they said if we can lock down this area, he's probably in these woods. They're making a guess. They didn't see him nowhere.
Nope, he's right here. Sheriff's Office Kane! Get the dog, Corey!
Yeah, I'm about to send you Corey video. I'm finna send you Corey. I'm finna send you Corey's video. Let my laptop load up. I'm back at the house. I'm letting my laptop load. I'm
So
finna
this
send you
one
Corey's video.
this one here is the A&E.
Right.
Deputy Corey LeBrecq arrives on the scene.
Now watch Corey. The dog was already on the ground before Corey.
I can't do it like that. Exit full screen.
Go give me that box, baby, please.
It's not playing now. Go. Dang it. Where is that at? It's not playing. playing now.
Multiple stop sticks are deployed, which punctured 3 of the driver's tires, and he keeps going, traveling at speeds as high as 113 miles an hour.
Could you bring the abstract too, honey? Thank you.
Residential street, but the driver makes a quick move around this pickup truck onto the sidewalk and speeds away.
You can't see nobody in that car.
But as the deputy is communicating his plan, the suspect suddenly appears. Deputy Corey LeBrecq arrives on the scene with his canine partner, Murphy. When the suspect fails to comply, canine Murphy chases him down.
Dang, they got the dog, bro, coming in, trying to bite you and everything, bro. Who did you harm? Marcus, who did you hurt?
I ain't hurt nobody.
We ain't nobody say they got hurt.
There wasn't no verified complaint. There wasn't no affidavit. There wasn't no sworn affidavit.
Nope.
No warrant, no nothing.
No, nothing.
So nobody was hurt.
Nope.
He hurt their feelings. That's what gonna hurt.
Say that again.
Because they couldn't catch him.
Yeah, their feelings. Yeah, their ego. Ego was bruised.
I'm just trying to figure out, like, who got hurt and why are they so serious about trying to hurt you, bro? That's what I'm trying to understand. Why are they trying to hurt you?
That life for me. What I saying that? Give it to me, please. Thank you. I love you for the greatest.
Eventually, deputies get the suspect in cuffs.
Okay.
Look at my boy out here bad. Look at him. Look at this, y'all. Look how they did him.
Is kicking me in the face and keeping his foot between my neck and my shoulder.
Oh my god!
And holding me down to the ground while the dog is on me.
Driving while license suspended, habitual offender, and resisting.
And instead of telling me, "Let go of my dog," I can't let the dog go. The dog ripping me. How do you want me to let the dog go, man? You want the dog? The dog trying to kill me. Actually, he's trying to get up to my neck.
You want to stop him? Look how they did my boy, y'all. They had him plastered on TV on A&E, y'all.
Oh, I got my videos on here. I got to do it.
This is crazy, bro. This is wild.
Defamation of character.
I'm telling my boy, this is wild.
Yes, bro.
Did you already send it to me yet, Marcus?
No, I'm getting this. My laptop is kind of.
You good? You good?
Yeah.
So after all this had happened, what you got out? You bonded out of jail. Okay.
Yes.
You're out of jail as you're just working and stuff like that. You've bonded out of jail. Go ahead and find what you need to find on your computer though at the same time. You've bonded out of jail, and you're getting to the point where you've hired this attorney. This attorney is shit. He's not doing what you know to be done.
Right.
You're telling him the truth over and over, yet he's acquiescing to the story or narrative that the cops and deputies are pushing forward. Okay.
Right.
He's got a duty to honor the court first before he honors you, and I guess he's just sticking to the story of what's being presented. You're coming up on a year and a half, I'm assuming, a little bit over a year that you've been working on this, and then you find us and you come in and you start asking questions. You're like, I have to figure out something.
Today makes 2 years.
Okay.
It happened on April 4th, 2024.
No way, for real?
Well, yeah, I think today makes 2 years.
Oh man, it didn't be sure.
Today makes 2 years. It happens today, last year.
Wow. The universe, bro, has been lining up so clearly, bro. For like,
y'all see that? That is crazy. It happened on April 4th.
Bro.
Today, 2 years from now.
Chill, bro.
The Most High is real.
Okay.
It's real.
That's tough right there. That's tough right there, bro. Okay, so he's figuring out that again, this attorney is not working for him, not doing the best. I don't know why my thing is like that, but I think I'm getting a call. And so what he's doing is he's trying to figure out, how do I, first off, get myself in order to where I don't have to deal with such egregious actions being brought forth against me. Let me see if I can fix my camera. Sorry. Okay, there we go. against me by at least learning something myself to then start trying to force an action upon the attorney in which I'm paying. So not only is he paying him to try and help get him out of this situation, but now he's having to go and look and educate himself to tell the lawyer what to do. Okay. And the lawyer is doing it or not doing it, Marcus?
Not doing it.
Okay. So then we get to the point where he's reached out to me. I'm looking at it like, whoa, this is kind of serious. These people actually are trying to put you in a certain situation that is very, very hard. I'm thinking of between everybody that I got going on, plus Marcus, I'm trying to figure out how do I get the situation to where he can put himself in a better position, right? And throughout all the work, I think we did kind of produce some things that were put forth in a somewhat of a strategy. But then that's when I thought he needs someone close. He needs someone close that I know that I can trust, that at least can do some research with your boy and look at the situation and be like, hey, dude, what's going on? Like, what options do you have, right? And let's really study together, looking whatever way we can, through any law book or criminal rule of procedure. And what we ended up having is just the introduction between Steve and then Marcus. Okay. And then what I know that y'all did introduce yourselves and you kind of brought in a little bit of what y'all were doing when you first met. But again, I want to get to the point of, you went to court and Marcus showed up to your court, right, Steve?
Yeah, well, he showed up like right after my hearing was like about 5 minutes. He showed up like right after I got out of that hearing.
Okay. And then what I want you to do is I'm going to use the restroom real quick. So kind of just take the floor for just a little bit. But what ended up happening once y'all met face to face? And kind of take it from there for a little bit. And then we'll move into strategy and then what happened kind of sort of. Okay. Okay.
All right. So immediately, we just came from a hearing. Marcus stays about like an hour and a half away. So this is kind of like early morning. So we just went to go eat breakfast and just really, I was giving my breakdown, just really introducing to Marcus who I am, kind of like how I got in contact with Cam. I was letting them know the things that I've learned. Cam basically came down and really showed me like some AI assistance. And, I initially told Marcus, like, look, I don't want to do this for you, but, I kind of want to just kind of introduce you to the tools, that I've been using. And I think Marcus, I showed him, ChatGPT, Perplexity. I told him about Manus. And it's like, what I've come to understand, if you're doing this process, you can't just rely on one AI assistant at all. You know what I'm saying? Because I've had where one AI assistant, I guess guided me in one specific direction. And then I had my other assistant come through and kind of like correct that direction and balance it out. So you kind of you will need more than just one assistant. But for my introduction, it just was to let Marcus know, like, look, I'm in the same boat, or I've been in the same boat, same position that he's been in. And it was, great to have someone like Cam to like get in the situation with me, but kind of empower me and educate me at the same time, not just me relying on Cam. So I was kind of like trying to do the same thing with Marcus, like, yo, man, brother, look, I'm here with you. I analyze the situation, but here are some tools, so that you're gonna need. And as you go through your case, I'll walk you through, like, how to go and basically use the assistance to your benefit.
Right. To go and find research and develop things particular directly to your situation. Right.
Right.
So back in the day, for us to understand what was going on, what did we have to do? We had to depend on another who we thought would know the information and present it best to us to get us out of the situation. We used to think that lawyers were here to fight for us. When we paid them, it was like, bro, I don't care what you did. I'm getting you out of this. Right.
No, it don't work like that.
It don't work like that.
Matter of fact, to be real with you, in kind of a subtle, you know, conniving kind of way, have I seen it? It's actually the opposite.
Yep.
You know what I'm saying? In reality, it's not
Now, is
something.
that whether it's paid or whether it's or whether it's court appointed, or is it just both ways?
All of my attorneys have always been paid, and I've always ended up in the same result.
You know, this is very similar to another case that we had in Florida, which is Hayden. I know Operation Wisedome is very familiar with Hayden's situation and his DUI. Again, Florida, okay? And when one comes through and hires an attorney, pays him $5,000, the attorney says, I'm not giving you anything back because I've worked 83 hours. Yet all the lawyer had did on the record, and to prove what he had worked that he had done, was to go and try and say that he was getting a DMV hearing. How do you work 83 hours and not submit one motion or notice? Or even go to a hearing whatsoever? You didn't. You're a bold-faced lie, okay? That's why Hayden dismissed that lawyer, went into an evidentiary, questioned the officer like no other, to where the prosecution had to do a nolle prosecute because it's all fruit of the poisonous tree, okay? So, again, example after example of what's happening. These lawyers, these attorneys, these bar cards are not fully representing the people.
No.
And now that we have the tools and eligibility to teach ourselves directly to the situation at hand, we have the power.
Yeah.
But you have to recognize that you have that power by putting in the time, okay? And if there's certain things that you may not possibly understand, why not reach out to another person to have a different perspective? Because the perspective is everything. That's why Operation Wisedome is what it is. The perspective makes the overall outcome of what we see and achieve, right or wrong.
Yeah, absolutely.
And the overall arching theme here, and what we believe in and understand to be, is that we are creations of the Creator. And until we harm another, there's nothing that can be brought forth against us. These statutory, colorable laws, codes that they have established are nothing but colorable. They're not real law. When you stand true within yourself and on your faith, knowing who you are as far as the creation of the Creator, nothing can stand against you. And when you have that knowing within you, I guarantee you're going to find a way.
It's done live already?
I guarantee you're going to find a way.
Mm-hmm.
All right. So now I want to say, so finding in that way, right? The great Creator allowed Marcus to find me, to then establish a connection between Steve, right?
Mm-hmm.
And these people unified together because they both had cases going on. They both did research together. They both compared each other's situation. And then they reached out to the Wisedome and even went further. All right. And in such, what occurred? Well, Marcus, you tell us what started happening. What moves did you make?
Right now, we had our assistants, you know, they were fighting back and forth.
Yeah.
You know, and we came up with some great results. You know,
Yeah.
they started coming together because they see that we were sharpening each other, iron sharpening iron. So what we did was on February 13th, we filed a C4 motion to dismiss count 1, 2, and 3.
One moment. Steve, did you send that to me or no?
Yes, that's the one that you got.
All right, cool. I'm going to go ahead and share it. Let me open it up in preview real quick. Hold on. Desktop. Sure. Open in preview.
Okay, yeah, I got to send you this video. Okay, so I got to send you this video. You got to get this video. All right, so
we got 11 pages on this one. Continue to scroll. All right.
It was there was a purpose I sent you that one. Because it has the judge's review.
Okay. Well, I don't know if you can see my screen or not. Can everybody see my screen? Are we good?
Yeah.
Okay. All right. So we got the judge's review. As you can see, top right-hand corner, we got a stamp coming through the felony division. Okay. You can see it. Felony division.
Felony division.
February the 18th to 26th. Okay. And it's coming from Kinsey. Looks like Marcus is on this bad boy. The attorney is Roxanne. Pro
Right.
se. Pro se.
Really, this right here is the most important
Most
part.
important part. Oh my God.
Okay, you have to
Okay,
understand about this part.
wait. Then let's not do that first.
Yeah, go
Where's
ahead.
where's your is this your motion to dismiss right here?
Yes.
Yes.
Okay. All right. So let's go through that first. Good. All right. So again, what we can notice is well formatted, February 13th. Okay. We've got criminal division, case number. Now we have a rule in Florida. Listen, in Florida, we got a rule 3.190C4. Okay. The shortened version of this is a C4 motion. When you hear them referencing C4, it's because of rule 3.190. Okay. This is a motion to dismiss all counts 1, 2, and 3. Comes now the defendant Marcus appearing specially sui juris and pursuant to, again, specially in sui juris, pursuant to Florida Rule of Criminal Procedure 3.190C4, and it moves this honorable court to dismiss counts 1, 2, and 3 of the information on the ground that there are no material disputed facts, and the undisputed facts, together with the four corners of the state's own charging documents, fail to establish a prima facie case of the offense charged. This motion implements the fundamental principle that when the undisputed facts do not establish any crime under Florida law, the state lacks authority to prosecute. CFB versus State 852 in a 2003 case in support, the defendant states the procedure, posture, and charges. Number 1, Blake County Sheriff's Office issued Florida Uniform Traffic Citation, charging defendant with operating while driver's license suspended, canceled, revoked, third, or subsequent, in violation of section 322.34 subsection 2C. That citation checks driving while license suspended or revoked, but contains no allegation that defendant knew of any suspension. Intent. Intent, right?
Intent.
How are they going to show and prove that the defendant knew of any suspension? Did they do a registered mail and have a signature? Did they have a picture of Marcus receiving that notice by any form or fashion? Or did they just possibly mail it out to an address which homeboy may have not even lived at, or may have not, or he may not have even received, or possibly mailed to another address? Right?
Actually, around that time that they sent that letter, supposedly, I wasn't staying there because I had got shot and I had got airlifted. Flew me to Gainesville. I was there in like 5-10 minutes, less than 10 minutes from where I stayed at, from that address right here in Leesburg. Guy tried to rob me. I didn't go to court or nothing. I didn't see no face or nothing, I didn't know who it was.
Dang, Marcus, you've been going through it, bro. Damn.
Yeah, so, yeah, man. Well, I have a story. I'm about to write a book like you, Cam.
Oh, man, let's do it, bro. You should, bro. Testimonies are the greatest, bro.
Go
ahead.
A couple of, you just look at it, tighten me up where I need to, but, so, anyways.
Hold on. Jack got a question. Go ahead, Jack.
Okay. Yeah, so for the proving intent and the knowing of this violation, couldn't someone argue that because he ran would imply that he knew he didn't have a suspension?
No.
Who's to say that he ran?
No, hold on. So in Florida, there is 3 elements. that makes up DWLS.
Wow,
right. So the one element is that you have to be driving.
Mm-hmm.
The second element is that your license has to be suspended. And the third element is that you have to be known.
Yeah.
Right. So even if you're running or whatever, that doesn't mean, that you had knowledge that your license is suspended.
Yeah,
all
Jack.
Right? And hold on.
Jack likes to play devil's advocate here.
Hold on, wait. And let me and it's not necessarily whether you knew, whether it was certified or anything like that. The actual citation has to state, so the officer has to make that allegation in the citation. So the 4 corners of the citation has to allege. So it doesn't. So even if, you did get a letter in the mail, didn't get a letter in the mail, the officer needs to make that determination or make that allegation on the face of the citation for that charge to move forward.
Well said. Perfectly said, by the way.
I have somebody getting their case dismissed right now because of that specific allegation. So
that's beautiful. Beautiful.
Yeah.
Number 2, the state later filed an information in case number 224 CF, whatever. Count 2 charges, quote, driving while license canceled, suspended, or revoked as habitual offender. Okay, pursuant to 322.345 and 322.264, alleging that defendant, while his driver's license was canceled, suspended, or revoked, pursuant to Florida statute 322.264, habitual offender, did drive a motor vehicle upon the highways of the state. The information omits any allegation that defendant knew his license was canceled, suspended, or revoked. Number 3, the arrest affidavit, probable cause narrative, states that a check of defendant's driver's license, showed that he currently holds a suspended license and has 6 prior DWLS charges, and that he was issued criminal citations for fleeing and eluding and DWLS third or subsequent offense. The affidavit is silent as to any notice to defendant, any mailing, service, or communication from DHSMV, or any admission by defendant that he knew his license was suspended. Number 4, count 1 of the information charges defendant under section 3.16.19351 with fleeing or attempting to elude, alleging he did operate a vehicle and having knowledge that he had been directed to stop such vehicle by a duly authorized law enforcement officer, did willfully refuse or fail to stop. The underlying UTC for fleeing cites section 3.16.1935.3a, not section 316.1935.1, and describes fleeing elude officer disregard safety of others. Count 5, number 5, count 3 of the information charges defendant under section 843.02 with resisting law enforcement officer without violence, alleging that the defendant did knowingly and willfully resist, obstruct, or oppose a law enforcement officer, to wit, the arrest and detention of the defendant in the lawful execution of legal duty. Number 6, defendant now files this sworn motion asserting additional specific facts as to counts 1 and 3, fleeing and resisting, and relying on the 4 corners of the UTC's information and affidavit as to all 3 counts. So, section 2. Defendant's sworn facts for purpose of Rule 3.190C4. What is the importance of this right here, Steve and Marcus?
Say it again.
What is the importance of this right here?
What is the importance of which one?
This section 2, the defendant's sworn facts for the purpose of Rule 3.190C4.
Oh, yes. So, okay, you want to answer it, Marcus?
Well, I'll let you go ahead. I'll let you answer.
All right. So there, the C4 motion or the Rule C4, right, is basically saying that your document has to be sworn, right? So you basically have to say, look, I swear, you know what I'm saying? These are true, right? Now, the state has to rebut your allegations in the same manner. They have to swear, hey, no, we're going to challenge these allegations and we can swear to it.
Okay, now I really want you to hit home for this, for real, because we're going to come later on why something failed, right? Why they failed.
Right.
Okay, hit home on this again, please.
Okay, so the sworn allegations, right? You have to swear. Hey, look, I swear. You know what I'm saying? This is the truth, right? Now I'm going to go further. Now the state has to also challenge timely. No, we swear that the allegations are false, okay? Now, if they do not timely swear that it is false, then everything in this document as a matter of law, not opinion or discretion, has to be admitted as true.
Thank you.
That's it.
I hope y'all are listening.
As a matter of law.
Matter of law.
So
I hope everybody is listening.
Yeah, man, listen, y'all got to be wide awake to that because that is the most important part.
It really is.
Because 9 times out of 10, whatever your sworn allegations are, the state probably can't swear to it and probably won't swear to it. And generally, what they'll end up doing is doing what's called a boilerplate response, which is basically state, Look, man, we have enough evidence that we can prove at trial. We don't need to basically need a response. And that is absolutely false, at least in the state of Florida, because there is DCA case precedents that state the state has to specifically rebut those allegations. And if they cannot, as a matter of law, your C4 has to be admitted as true. It's not an automatic dismissal. It has to be admitted as true. And then the trier of fact has to take your allegations against the charging elements and to see if the charging elements can be charged based on your true statements. And if it cannot, then the case has to be dismissed.
Thank you.
Sounds like a remedy.
Hey.
Oh,
Sounds like a common
it's
law
straight to the
remedy.
point.
Oh, yeah.
It's straight to the point.
Yeah, let's get to it.
Some
number
people
two.
spend years trying to figure that out.
No, that's it right
Yeah.
there.
Okay, let's get into it. So number 2, defendant's sworn facts. Again, for the purposes of Rule 3.190C4. 7. On April 14, 2024, defendant was a passenger, not the driver of the black Maserati identified in the arrest affidavit. He was seated in the rear seat of the vehicle at all times it was driven before the crash. Number 8. Defendant was intoxicated and resting in the back seat. Another unidentified individual was operating the Maserati from the driver's seat. Number 9. When law enforcement first activated lights or sirens or otherwise attempted to effectuate a traffic stop, defendant had no role in operating, controlling, steering, or directing the vehicle and did not make any decision whether to stop or to flee. Number 10. After the Maserati crashed, both the driver and the defendant exited the vehicle and ran from the crash scene. Defendant was the only occupant apprehended. The driver escaped. 11. The defendant does not dispute for the purposes of this motion only that law enforcement believed the vehicle to be speeding and deployed stop sticks, nor that he later fled on foot from the crash area. However, he never operated, drove, or controlled the vehicle at the time of any order to stop, nor at any earlier point in the events described. Hold on one second. What do we got here? Mute. Okay. Number 12, defendant further swears that prior to his arrest in this case, he did not receive actual notice that his driver's license had been suspended, canceled, or revoked, and he did not know that his driving privilege was in a suspended, canceled, or revoked status on April 14th, 2024. Defendant tenders these sworn facts for the purposes of Rule 3.190C4 only without waiving his right to remain silent at trial. So now we're moving into Section 3, which is the governing law. Rule 3.190C4, motion to dismiss. So under Florida Rule of Criminal Procedure 3.190C4, defendant may move to dismiss where there are no material disputed facts and the undisputed facts do not establish a prima facie case of guilt against the defendant. If the state cannot traverse with specific facts that, if true, would establish the missing element, dismissal is required. A traverse must set forth specific material disputed facts which, if true, would establish a prima facie case. Mere conclusions that, quote, the state can prove its case at trial, unquote, are insufficient under Rule 3.190C4. See State versus Calageropoulos.
Calageropoulos.
It's okay, I had a problem with that word too.
Yeah.
That's Florida 2000. Also,
There you go.
State versus Upton in 1995. B, knowledge is an essential element of the DWLS. Okay? Under Section 322.34. Section 322.342 Florida statutes provides that a person, quote, whose driver's license or driving privileges has been canceled, suspended, or revoked, who knows of such cancellation, suspended, or revocation, and who drives a motor vehicle, unquote, is guilty of DWLS with subsection 2C, elevating the third or subsequent conviction to a first-degree misdemeanor. Number 15, Florida courts have held that knowledge of the suspension is an essential element of DWLS, and that omission of this element is fatal. Again, in Linehan versus State, 1983, Florida, you can see here, everything's coming back to Florida, y'all. They're not reaching out anywhere else or Marcus is not reaching out anywhere else in his documents. He's strictly going right to Florida precedent.
Is that the element of willfulness?
Here in this case?
Yeah.
Oh, I don't know.
Well, hold on. What
this is the first time I'm
question?
actually reading this one.
Hold on, what was the question?
I'm saying him not knowing that's the element of willfulness. They have to prove that he willfully done that crime.
Oh yeah, knowledge.
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 Well, the
And
knowledge.
the intent.
If it's for DWLS, knowledge is an essential element, and the knowledge has to be alleged in the ticket. If it's not on the ticket, they can't say, "Well, no, we'll just show the driving record, or we can just show that it was mailed." It's insufficient. It has to be on the ticket.
Willingly, intentionally, and knowingly.
Yeah, knowingly is one of the elements.
Yep. So the Florida Supreme Court emphasized that where a statute requires knowledge, the state must both allege and prove that the defendant knew
Allege.
the
he has to allege.
prohibited status. And failure to allege the required mens rea, I love it, renders the charging document defective. Perfect. In Davis versus State, in 2006, DCA, the district court reversed a DWLS conviction where the state failed to present sufficient evidence that the defendant knew his license was suspended. I don't know what you're talking about in Florida. Willie, listen, Willie.
Listen, you get pulled over, you gotta be like, "What? For real?"
Listen, we're gonna go over this one more time.
I didn't even know that, man.
Man, that's crazy.
We're gonna listen to this one more time. In
Hey,
Davis
can I ask
versus
a
State.
question?
Damn.
Yeah, go ahead.
Yeah, is it so if this is in there and they have to know it's got to be on the ticket,
It's gotta be.
it's got to be on the ticket. This you don't even have to say anything. You don't have to say I didn't know. That's testimony. You can literally say they didn't show.
Yep.
Without ever you giving testimony cross that bar.
You don't have to talk at all, bro. All you have to do is
Well, I
present.
mean, you
That's
say the
case.
words. You say the words they haven't shown.
Well, I mean, what I'm saying is in your stop, though, you don't have to do anything but present if that's the case.
Yeah. But if they say, "Hey, your license is suspended," you got to be like, "Man, I didn't know that." If body cam is activated, you know what I'm saying? You can use that later.
Yeah,
And you
y'all
can
were
swear
saying
to
two
that.
different
You can-
things.
Hey, hey, Cam, I heard what you said. So this whole time since I've been
Well,
down
listen.
here,
Well, wait. Listen, I'm going to read it then since you're listening closely. So in Davis versus State, okay, and this is a DCA in 2006 there in Florida, the district court reversed a DWLS conviction where the state failed to present sufficient evidence that the defendant knew his license was suspended, underscoring that knowledge is a necessary element under section 322.34.
now
Willie,
Yes.
my question is this. How could you know your license was suspended if you never applied for a license in Florida?
That absolutely. Matter of fact, as I said, the last driver's license I had when I was about 25 years old, and I never knew that it was suspended.
Damn.
Yeah.
You would never say that out loud, though.
Shit, he just did. All right.
No, I mean, court.
No, I know. I'm just playing. Listen, these authorities make clear that knowledge is not a mere sentencing factor. It is a part of the corpus delicti of DWLS.
Damn.
Yeah, bro.
Whoa.
Marcus ain't playing, bro. Marcus is
That's
not fucking playing.
Juicy.
I'm telling you, bro.
Yeah.
Genius. Genius.
Got a pretty girl on one side. I got this on the other. What to do?
Okay, listen. We're only on page 4 of 10. We got to get through this, y'all. All right, come on. All right. So the commenters of practice guides likewise recognize that section 322.34 requires proof that the defendant knew or had been notified. Doesn't mean just because you mailed it out. It also must be proof that you had been notified of the mailing. Okay. And that notice problems are a frequent ground for dismissal or acquittal. 17. The extent of the information citation to section 322.345, habitual offender, could be construed to omit an express knowledge requirement. Such a construction would raise serious due process concerns by imposing criminal liability absent any allegation of mens rea. This is inconsistent with the Florida Supreme Court's requirement in Linehan, that where knowledge is a part of a status-based driving offense, it must be both alleged and proved. See also Morissette versus United States in 1952, where it states that the criminal liability ordinarily requires a union of an act and mens rea. An act and mens rea. So actus reus and mens rea.
Corpus delicti.
And where a statute expressly includes knowledge, the charging document must allege that mental element as well. C. The elements of fleeing or attempting to elude under section 316.19351. 18. 316.19351 Florida statutes provide that it is unlawful for an operator of a vehicle having knowledge of an order to stop by a duly authorized law enforcement officer to willfully, hear these words, refuse or fail to stop in compliance with such order, or having stopped in knowing compliance to willfully flee in a vehicle. 19. Thus, the state must establish as to count 1, A, defendant was the operator of the vehicle. B, a duly authorized LEO in an appropriately marked vehicle with lights and siren as required directed the vehicle to stop. C, defendant had knowledge of that order to stop. D, defendant then willfully refused to fail to stop or fled in a vehicle after stopping. Number 20, the treaties and secondary authorities discussing fleeing and eluding emphasize that the statute targets the driver who makes the decision to disregard an order to stop, not a non-driving passenger who may later run on foot after a crash. D, elements of resisting officer without violence under subsection or under section 843.02. 21. Section 843.02 Florida statutes provides that a person who resists, obstructs, or opposes any officer in the lawful execution of any legal duty without offering or doing violence to the person of the officer is guilty of a first-degree misdemeanor. The essential element is that the officer must be engaged in the lawful execution of a legal duty at the time of the alleged resistance. See CEL versus State in Florida 2009. If the underlying arrest, geez, I need to get something to drink. If the underlying arrest or detention is unlawful because no crime has been committed, the, quote, lawful execution of a legal duty, unquote, element cannot be satisfied. Now we're coming into the argument. Count 2 DWLS fails to state an offense. A, the information omits the essential knowledge element. 22, count 2 of the information alleges only that defendant, quote, while his driver's license was canceled, suspended, or revoked pursuant to Florida Statute 322.264, habitual offender did drive a motor vehicle upon the highways of the state, unquote. Incites section 322.345 and section 322.264. It never alleges that defendant knew his license was canceled, suspended, or revoked. 23, under section 322.34 and the case law interpreting it, knowledge of the suspension is an essential element that must be pled and proved. And information that tracks only the status in driving language omits the who knows of such cancellation, suspension, or revocation language and fails to state a claim. Sheesh. 24. The underlying DWLS citation similarly lists only, quote, operating while DL suspended, canceled, revoked, third, or subsequent, unquote, with a reference to section 322.342C and does not allege knowledge. The arrest affidavit notes only that a license check shows that he currently holds a suspended license and has 6 prior DWLS charges. Again, without alleging actual or constructive notice to defendant. 25. Under Linehan versus Ann Davis, an information that fails to allege the required mens rea does not charge a criminal at all and is subject to dismissal. It's a complete failure, to be matter of fact. Complete failure of the elements essential to actually charge my boy and put him under arrest. The omission of the knowledge element in count 2 is thus a facial defect apparent on the 4 corners of the information and not curable by proof outside the record. Sheesh. American jurisprudence number 26 and general criminal law procedures further support that where the legislature has explicitly made knowledge part of the offense. Okay, let's again listen to it. American jurisprudence. Who are we talking about here when we talking about this first part of this sentence? Who are we talking about?
American jurisprudence.
Yeah, who are we talking about in this first part? I'm gonna read it again, and y'all gonna tell me who's got it. There's a certain title I'm looking for of people. Okay, American jurisprudence and general criminal law principles further support that where the legislature has explicitly made knowledge part of the offense. Who makes this offense? Who's making these offenses?
The legislator.
Oh, thank you, the legislators.
Yeah.
Okay, and what have they done within within the legislature? They made knowledge an essential element.
Essential element.
What rule would we apply as well that falls into this, where they can't go outside the statute? Come on now. Rule of what?
Lenity.
There it goes. Lenity. The rule of lenity. You can't apply. You can't go outside of the rule of the statute and its limits, and then hope that it holds. The rule of lenity applies. You have to stay within the boundaries. You cannot go outside. Cannot reach. They were reaching. How were they reaching? By not proving the knowledge intent.
Yeah.
Okay.
So this whole
again,
time,
they explicitly made knowledge part of the offense. Okay. And courts will not treat that element as optional or implied. Its omission from the charging document is fatal. It's a killer. The state's own affidavit confirms no allegation of knowledge. Sheesh, man. The arrest affidavit proves only A, that DHS&V records indicated a suspended license, and B, that the defendant had prior DWLS charges. It does not assert that notice of any suspension was mailed, served, delivered, or otherwise communicated to the defendant, nor that the defendant admitted knowing his license was suspended. A bare record of suspension is not enough. Knowledge cannot be presumed merely from the existence of a suspended license or status. In DWLS practice, courts regularly reject attempts to bootstrap knowledge solely from prior suspensions or prior DWLS history. Accepting as true facts asserted by the state in the information, UTC, and information record still does not establish that the defendant knew of any suspension on April 14, 2024. When the state's own documents omit an element that must be proven, and the defense adds sworn facts that the defendant lacked knowledge, there is no prima facie DWLS case under Rule 3.190C4. Because knowledge is both omitted from the information and unsupported by any factual allegation in the state's own attachments, Count 2 fails as a matter of law and must be dismissed. The argument 2, or 1, fleeing, cannot be sustained against the defendant on the undisputed facts. A, the undisputed facts do not establish defendant was the operator. The narrative in the affidavit describes the narrative, what's been brought forth. Not facts, but hearsay statements, right? How do we knock out those hearsay statements? What do we bring forth?
limine, right?
Limine. There you go. The narrative describes a speeding Maserati, a radar reading of 106 miles per hour and later 135, a police pursuit, deployment of stop sticks, and a subsequent wrecked vehicle. It then states that the sole black male was seen exiting the vehicle and began fleeing on foot, and that this male was identified as defendant. I don't think that's where they identified him. I don't think they saw him exiting the car. And if we look, as a matter of fact, from the body cam, it shows that homeboy was walking in the neighborhood, well away from the car. The affidavit reports that a deputy was able to see that there was only one occupant inside when the vehicle initially fled, but does not provide any underlying factual detail as to the distance, lighting, vantage point, or how the supposed single occupant observation was made. This assertion is conclusory. The defendant's sworn facts, paragraphs 7 through 11 above, state that there were two occupants and that the defendant was in the back seat, intoxicated, and that another person was driving at all relevant times. Those facts are consistent with the state's proof that a vehicle fled and later crashed, and that defendant later ran on foot. But they are inconsistent with the conclusory assertion that there was only one occupant. For purposes of for Rule 3.190C4, the question is whether, taking the state's non-conclusory factual allegations and defendant's sworn version together, the undisputed facts would establish the elements of Section 316.19351 as to this defendant. Even assuming probable cause existed to stop the vehicle based on speeding, the record does not establish that the defendant was the operator of that vehicle when the order to stop was given. A passenger's later flight on foot does not convert him into the driver for purposes of Section 316.19351. Because the statute criminalizes the conduct of the operator who willfully refuses to stop after an order, the absence of any non-conclusory facts tying defendant to the driver's seat at the time of the attempted stop is fatal as count 1 as to him. Knowledge of the order to stop is essential as established as a backseat passenger. On defendant's sworn version, he was not the person controlling the vehicle's response to any lights or sirens, and he did not make the decision to flee in a vehicle. His conduct was limited to running on foot from the crash. Such post-crash flight on foot, even if criminal in other respects, does not satisfy the elements of 316.1935, which requires a willful refusal to bring this vehicle to a stop after an order to stop. The affidavit likewise contains no conclusory facts showing that defendant as a rear seat passenger personally perceived or responded to any order to stop, as opposed to the driver. Thus, even apart from the operator defect, the state has no prima facie showing that this defendant had knowledge of an order to stop within the meaning of section 316.19351. Taking the state's factual allegation and defendant's sworn facts together, there is no set of undisputed facts under which the essential elements of count 1 are met as to this defendant as the operator. Under Rule 3.190C4, that requires dismissal. Hold on, I don't know who's speaking right now. You got to mute up, G. As to this defendant as the operator. Under Rule 3.190C4, that requires dismissal if the state cannot traverse with additional specific facts. Again, that requires dismissal if the state cannot what? Traverse with additional specific facts. Now, the argument count 3 resisting fails as a derivative charge. Count 3 charges defendant under section 843.02 resisting a law enforcement officer without violence. The lawful execution of a legal duty element requires that the officer be engaged in a lawful arrest or detention at the time of the alleged resistance. As established above, the state has failed to present a prima facie case for either DWLS count 2 or fleeing count 1. If neither of those offenses can be sustained against the defendant on the undisputed facts, then any arrest of the defendant for those offenses was not in lawful execution of a legal duty. The resisting charge is entirely derivative of the primary charges and cannot stand independently where the underlying basis for the arrest fails. Now, because the officer was not engaged in the lawful execution of a duty when arresting defendant for offenses that cannot be established as a matter of law, count 3 must also be dismissed. The variance of notice issues supportive of dismissal or limiting relief. The fleeing UTC cites section 316.19353A, fleeing elude officer disregard the safety of others, revoked by court. Whereas the information charges section 316.19351. This variance underscores the confusion about which degree and theory of fleeing the state is pursuing. Now, while the state is generally permitted to amend an information, such charges cannot deprive a defendant of a fair notice or alter the nature of the offense without adequate procedural safeguards. The discrepancy in subsections coupled with the absence of concrete facts establishing defendant as the driver supports the conclusion that the state has not articulated a coherent fact-supported theory of fleeing as to this defendant. Now, at minimum, this court should construe count 1 narrowly to the section 316.19351 theory actually pled in the information and not permit any constructive reevaluation to aggravated fleeing under section 316.19353A. Now, we got preservation of the appellate rights section. Okay. Again, the defendant expressly preserves all appellate rights, including but not limited to the right to appeal any adverse ruling on this motion. So any ruling coming about this thing, hey, reserved. Okay. And any denial or dismissal and any other order that may that may affect his substantial rights. This preservation is made in pursuant to Rule of Appellate Procedure 9.140. Conclusion and relief requested. So, wherefore? Wherefore? Yeah, wherefore? The defendant respectfully requests that this court, as to count 1 or count 2 DWLS, find that the count 2 of the information fails to allege that the essential element required by section 322.34 and controlling case law that's been presented directly out of Florida and that the state's own documents are devoid of any factual allegation that the defendant knew his license was suspended. That's an X, my boy. You know how they be up on the stage on I don't even know what show that is nowadays, but they be up on the stage and everybody's got the panel and they give them the X. That's an X. That's a big loud X for them bad boys right there. Okay, it's a loud one. We talking about when you out there watching hockey and it's the end of the, what do they call that? The period. They don't have quarters. They got periods. It's you dig what I'm saying? Shit's loud for at least
Family.
I'm trying to have fun with it a little bit. You do. So I gotta smoke a little bit. You do. All right. So dismiss count 2 with prejudice under Rule 3.190C4 for failure to state an offense and failure to present a prima facie case. As to the count 1, which is fleeing, find that the undisputed facts, including defendant's sworn facts, do not establish that the defendant was the operator of the vehicle or that he personally had knowledge of an order to stop. Dismiss count 1 under Rule 3.190C4 for failure to establish a prima facie case against this defendant, or at minimum, 3, limit the state to Section 316.1935, theory pled, and not permit any constructive amendment to a Section 316.19353A, aggravated fleeing charge, inconsistent with the information. Now, as to count 3, resisting, find that because the underlying charges DWLS and fleeing cannot be sustained. Again, finding that because the underlying charges, the initial initiation of, right? The officer was not engaged in the lawful execution of a legal duty and the resisting charge fails as a matter of law. Why does it fail? Why does it fail as a matter of law? Somebody please tell me, why does it fail?
Because there's no charge.
There's no charge.
You have to, the charge of DWLS would have to be standing, and the charge of fleeing eluding would have to be standing. But if Marcus was never the driver, but only the backseat passenger, those charges don't apply to him. So wherefore resisting arrest for those charges don't exist, because you can't arrest him for those charges. He was never in the driver's seat.
That plus they never knew for a fact that he had knowledge thereof.
Yeah.
The big X, bro. That's how. I love it. Dismiss count 3 under Rule 3.190C4. Okay. Got the verification, as you can see. All right. Now I've read this bad boy. Now I'm going to go back to page 1, and I'm going to start to let y'all take over on what y'all need to talk about. Come on now. Don't be scared.
So,
don't be scared now. Where we got Steve and Marcus on this bad boy. Steve, where you at? I'm gonna put on.
I'm about to jump in here in a second.
Okay.
I'll go to.
Should be back in a few minutes.
Do it like this. Do it like this. Okay. Do it like you explained to me, I guess, over the phone, where I've read through the motion. So that's, I guess, in my mind, how I'm thinking is of like, okay, I've prepared this motion. I'm ready to. We've prepared this motion. We're ready to go file this bad boy. Like we are winning. Me, myself, I, and everybody that has led me to understand and comprehend this knowing now of the statutes and elements, right? And you're about to present it forward because it's like everybody's talking, right? And y'all finally come to this conclusion, like, oh my God, this is it, and you've developed it. And you're so stoked. How are y'all coming to file this, and what is happening? Like, describe it for real, for real.
Okay, so on February 13th, I went and filed the C4 motion and a motion to dismiss counsel due to it was like May 19th. Of 2025, after I fired both of my attorneys that I hired, remember I told you I fired their attorneys, they forced a PD on me on the 19th of May 2025. So from there on out, all the way until February 13th, I filed the C4 motion, the motion to dismiss counsel. We went to the hearing. The state did not file a traverse. they had a window period of 2 days before the hearing to file a traverse or a demurrer.
Okay, now wait. Steve, you also explain this too right here. This part right here too. And then we'll keep going. Because I know Steve can elaborate on this one because he elaborated with me on it. Go ahead.
All right. Okay, so all right, so this
Yeah,
this this
this is
okay.
crazy. Yeah, this is
Okay.
crazy. Yeah.
All right.
Yeah.
So when so Marcus had got the PD put on him back in May. So I guess, right around October-ish, me and Marcus connected and he was giving me the rundown of whatever the situation was going
Yeah,
on.
baby. Here.
So I told Marcus, by him having a PD on him, the judge. Now here's this. Now I want everybody to know this right now. This is like so important
This is important.
because it's like I'm gonna speak about Marcus's case, but who that was? Let me see. Shit, where he at? Somebody earlier was asking about. He was saying, "Damn, this sounds like a memory, a remedy." I think that was Foster, right? So
Hey, real quick, just I want to shout out my baby Anya. Say hi, baby. Oh, she don't want to say hi. She's
shy.
Hi,
scared.
Anya.
Beautiful.
Say hi, y'all. Everybody say hi to Anya, y'all.
What's up,
Hello,
Beautiful,
Anya?
Anya.
Anya.
Hello.
Hello, Anya.
They saying hi to you, sweetie.
Hi, Anya.
Hey, look,
Hey,
they love you.
Anya, can you
Yes.
high five your dad for me?
High five, she said. He said, "Give me
High
a high
five
five.
your dad for me.
Come on, give me a high five.
Oh, you can high
Go,
five it. That,
go fast.
that was slow. You can do it.
Come on, give me a five.
All right, okay. How about a hug?
Hug. You want to give me a hug? Yeah, she'll give me a hug.
Oh, so sweet.
All right, Steve, keep going, bro. Sorry.
Yeah. So here's this. Like, this is we talking about Marcus's case, but I want everybody to mentally put this blueprint on you guys because this is and will happen damn near every single time.
Yes.
Every time.
He
This is
mapped it
it's
out
like,
too.
yeah, it's the court's blueprint to silence you.
Yes.
Yep.
You know what I'm saying? So what ended up happening is that, Marcus went in and his earlier filings were like a lot of constitutional things, just asserting his constitutional rights and whatnot. And I'm pretty sure a lot of people go in there, hey, these are my constitutional rights, and they don't want to hear that shit, to be honest with you. Right? I'm gonna give it to you blood raw.
Yep.
Right.
Immediately, if you go in and your language is anything other than their criminal procedural rules or anything procedure, if you go in communicating anything like that, they are going to immediately deem you incompetent.
Yes.
That's the first thing they're going to say. Constitutional what? That doesn't apply here, or you know what? You don't know what you're talking about. And the very first, I mean, this is like damn near 99% of the time, they are going to slap on a public defender on you immediately. They're going to deem you incompetent, and they're going to basically try to muzzle you.
Deem.
Well, can I say
That's some
100,000.
something?
bullshit right there. Need a written determination on that word deem.
Right. Well,
Yeah.
they're going to they listen. Now I will tell you this, right? Just like you said, you need a written determination.
Damn straight.
Okay. Well, I will tell you this. The court is going to abuse their
Their power.
discretionary
Of
power
course.
every
Yeah.
That's what
time.
they doing. That's what they doing.
You
And
understand what I'm saying? So, right. You know what I'm
Judicial
saying?
notice on the record and is the best you can do to hold your space and stand and not look like the one that can be trifled with, you know?
Right. But I'm just giving y'all the blue. I'm
Yep.
giving reality. You know what I'm
Yep.
saying? At
Can
the
you
end of
give
the
us an
day,
example
an example of
between coming in the common law and constitution, all this, and then speaking their criminal language?
Well, hold on, just real quick. Jed wants to ask a quick question. What you got going
go
on?
ahead,
You
Jay.
got your hand raised for a while.
Yeah, yo, my man Kim, I appreciate it, man. Thank you for letting me come through real quick. I'm exactly right where Steve said that I'm at, and I'm coming on new. I've been following for a while, actually a couple years, so I understand the language behind what you guys are saying. But I'm right where he said I was at. Taking care of a case, just administering. I call it like administering somebody else's like legal person or whatever. But it's my stepson really, and that's what we did. We walked in there saying, hey, this violates the constitutional stuff, did all that. And it's funny that he just touched on that. And I want to make sure we don't get silenced. That's the crux. You just hit it. That's the only reason why I raised my hand, man. And I came on here because I'm trying to catch pace with the team and where everybody's at, man. But I appreciate you touching on that. So I just wanted to throw that in there.
And I throw this in there too.
Yeah, go
Judge,
ahead.
are you prepared to make a written determination on this in defense of the substantive rights that I have? You have to take judicial notice, Judge. I require judicial notice of everything you're supposed to when a pro per litigant who is not a bar attorney appears specially in your court.
Do that on paper ahead of time. That's all in his paperwork.
Yeah.
Stand on that paperwork.
Yeah, because you do that in court, they gonna put you in contempt.
So here's what has to happen.
Say.
Well, let
Hold
Marcus
on,
say what he's finna say. Go ahead, Marcus.
Yeah, I was just gonna say just before you say that, whatever is in that paperwork, right, and it's stating anything about the Constitution, they're gonna tell you and label you as a U.S. citizen, and generally, a U.S. citizen is civilly dead in the eyes of the law. You can't speak. So, what we did was we had to do a Ferretta hearing.
Yep. That's exactly it.
Okay.
What is that?
You have to request it.
Wait, you know what a Ferretta? Wait. Danny just asked what a Ferretta hearing was, and I know he knows. Danny, what's a Ferretta hearing?
It's escaping me, Cam. Ferretta, Schmetta.
Think hard. Think hard. I know you know, bro.
Someone give me a hint. Ferretta.
No, we can't.
It's not even. Hold on. A Ferretta hearing is not even really a hearing. It's an inquiry where the judge asks you a series of questions.
Yeah. What questions are they asking you, Ferretta?
Right. Is it like I'm being wadir'd to see that I'm competent?
Yes.
To do what? To do what though? To do what? To do what?
Competent to defend myself and to
there you go. Okay,
to speak.
Right.
To defend yourself.
Now I remember. Yep.
Okay. You're competent. You're of the majority of the age to handle your own affairs.
And you had a proper education to be able to speak for yourself, because they actually what grade did you finish school and all that other stuff, which don't have anything to do with it.
Right. They also ask me that.
Did you go to law school?
Now, let me ask you this. They do ask a certain question as far as something that you should know as well. Do they ask you if you know the Constitution well?
Nope.
No, they don't. No, they don't. No, they don't.
Ask that.
They don't ask that.
Of course they
What do they ask? But what do they ask that you do know of, as far as rules are concerned?
The rules of
criminal rules of procedure.
The rules of procedure. You tell me how fucked up that is. Excuse my language. You tell me how. You see what I'm saying?
Right. I know excusing that. You right. You know? Yeah, man.
It's just like Steve was saying. It's just like Steve was saying. They don't care about the Constitution. It's just like Mark was saying. You mention anything about the Constitution, they go like, bro, what?
Yeah.
You're funny.
I deem you incompetent.
Anything outside of their procedural framework, you know what I'm saying? They're gonna ignore you and they're gonna deem you incompetent and so on. Now, I will say this: the easiest thing to do is to request or to stand on your Sixth Amendment right, because you all have the Sixth Amendment right to self-representation. So make sure you just simply say, look, I have a Sixth Amendment right to self-representation, and you let them know that they haven't done a Ferretta inquiry. Then and there, that's where that gets invoked. Immediately, the judge shall go into a Ferretta colloquy or inquiry.
Colloquy is the word I was looking for. Yeah, colloquy is the word I was looking for.
I'm just going to mention real quick, the Sixth Amendment, you have a right to assistance of counsel. Yeah, you have the right to represent yourself, to present yourself and handle and litigate this yourself as well. But that also includes the right to assistance of counsel, so that
I was just going to say, co-counsel. I can bring on any counsel that I want.
Well, check
now,
it.
Be careful. They might get hit with the UPL.
Yeah, UPL. Because watch out, Marcus. Joe Ellis is the king of UPL right now. Okay, when it comes to UPL experience, Joe is the go-to. I want everybody to know that. he done went through that and won that and beat it, and literally had the whole district of judges recusing themselves. Okay,
Damn.
like it's no joke. I'm for real, bro.
Damn.
I'm dead ass.
10
All judges.
10 counties, 10 counties of district judges had to recuse themselves, and they had to bring in another judge outside.
You see what I'm saying? Yeah. Joey playing, bro. So when it comes down to UPL, I should go to. So
I need to holler at Joe.
Yeah, Joe.
Yeah, we're gonna get with Joe real soon.
All right.
We're gonna get in there.
So let me
You
go
guys are
ahead
awesome.
and land the plane though on the situation.
Okay, I'll bring it up. I'll bring it up right now on full screen.
All right, I'm gonna go ahead and land the plane on that. So the procedure is the very first thing that they're gonna do is try to deem you incompetent and slap a public defender on you, even if it goes against the Sixth Amendment, whatever your rights are. Like I said, they are going to abuse their discretion any way possible, especially when it sounds like you know a little bit of what you're talking about. Because at the end of the day, they do not want to lose. That was a very comprehensive C4 motion.
Yep.
And I will tell you, that C4 motion was a threat to the state and the court. And please, I want to let everybody know, even if you have a comprehensive motion like that, it's a threat and they are not going to honor it. As a matter of fact, they are going to go above and beyond their discretion, you know what I'm saying, to turn it down. So that was a very, very, very great C4 motion, but it serves another purpose. And you read it at the very, 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 very last bar, which is we preserve appellate review.
Mm-hmm.
You know what I'm saying? So when you're doing your motions, you're not doing it for the trial court. You're doing your motion for the appellate court. You are supposed to expect that the judge spits on it and throw it in the garbage. And that's exactly what you want. You want your motion to be disregarded.
Yes.
You want your yes. You know
Now let me ask you this. I know that you come through with the C4 and 1, but at this point, you're mainly just working in the statutory framework and body of law, right?
Yes.
And so there was never a need to bring forth a notice and demand within the constitutional framework and body of law, correct?
No.
So even within the statutory framework, we still can see that remedy can be given.
Yes.
Yeah,
right.
I have a question.
Yep.
So I'm from the state of Florida too. I'm in the same state, and for some reason, you know, I've been having to disqualify these judges. But the main issue is they refuse to give you a written determination of why they deny your motions.
That's fine.
And for some,
no, that's fine. That's to be honest with you, I'm gonna tell you this. I didn't mean to cut you off, but I want to save you some time, and I want to tell you that's actually a good thing, because there was a time where I used to file motions, and I didn't get the results, and I was pissed, like, oh man, this is some bullshit. You know what I'm saying? And now I look at it like, all right, bet.
Yeah,
You know what I'm saying?
I want to add on.
Appellate review.
Yeah, exactly. So Marcus, I want to add on to that. You guys need to go in here, just like Marcus is saying, go in here with the expectation.
Steve was saying that one, but yeah.
Oh, sorry, Steve. Yeah. You want to go in there with the expectation. What you're doing when you're making your filings, you're perfecting your record. You're setting it up so that if anybody opens up your file and reads it and they see what the claims are, what you're doing, your file, your paperwork is your court record. And you want to be able to go into any court, go to any court and say, this is the case file. Here it is. This is where the lower courts erred. So you're building your case against the lower courts so that, they could do whatever they want and everything else. But when you make your filings and you preserve those errors, now it's important that your filings, if you just make these filings and you don't bring them up at court to bring them before the court, the appellate court is going to look at that and say, well, where did you preserve that error? and if it's only in your filings and you don't actually bring it before the court at the time of trial or whatever it is, you need to be able to point back into the record, the transcript or whatever it is that says, hey, this right here, this notice, page 4, line 3, is where I brought it up, and we need to deal with this. And so anyway, my point is to piggyback on what you said, Steve. Yes, go in here. All of your filings are to perfect your record so that when you do get to a proper court of law that's going to respect the law and not these statutes and codes and rules and all this other BS, is that you have your file and you're ready to go, and you can pinpoint where the lower court is and they erred. So anyway, I just wanted to.
And I wanted to chime in real quick too, because I do know that, like, I hear both Steve and Marcus earlier saying, "Oh man, you bring forth the Constitution, they ain't gonna listen to you." That is true, but that's under the statutory framework. Okay, now you got to really understand. We've got judges that are on the record, bro. Okay, stating that it depends on what documents you bring forth that establishes which body or framework of law that they're going into. Literally, we got one with Luis here in Washington where he said, well, man, you really brought this motion to dismiss, which is a statutory motion under 8.3, so I got to address it like that, right? He said, now, if you would have brought forth the notice and demand as unconstitutionally applied with the points and authorities, then I would have been in a different body and framework of law, which is constitutional. So right on the record, we got judges letting us know that there are frameworks within how they approach and decide in the courtroom, how they're essentially operating. I mean, you essentially got it like this. You got the statutory framework, you got the constitutional framework, and then you got a court of equity. Okay? And how you get to those is how you move the court. What documents are you bringing forth to move the court? Okay?
Right.
So I just want people to kind of remember that, so that frame of mind as far as thought doesn't get lost as well. Okay, so let's now move into for the judge's review.
Right.
So we're going to go back to page 1 now.
Okay. This document is super important, particularly in this case for Marcus. Okay. So remember I was saying, so we were talking about originally how Marcus had his public defender thrown on him back in May. Me and Marcus, we got together and, we decided that we need to get this public defender off and we need to do the C4 motion. So he filed 2 motions at the same time. He filed the C4 motion and the motion to remove counsel.
Okay, just quickly. Nina, I see that you just joined. I want you to stay in here. I want to talk about your situation in Florida as well. Steve, please continue.
Damn, we got a lot of people in Florida.
Yeah. So he filed those 2 motions, right? So now the judge reviewed the motions and I want you to scroll down a little bit, Cam.
Okay.
Scroll midway of there. All right. You can go just a little higher.
Okay.
Or a little lower. Rather.
Okay.
All right. So now here it says judge's comments, right? Right there it says there's 2 parts that he can mark. He can say that the defendant is represented by an attorney. Pleadings filed by the defendant who is represented by an attorney are nullity. Please ask your attorney about filing certain pleadings. See Burke versus State, right? So the judge can strike your document as a nullity, or he can respect it and set it for short matters hearings like he did in this one. He says your request will be placed on the short matters docket. You will receive a notice for trial or a notice in the mail. So why this is important, especially in this case, is that he set it for the short matters docket. This was on February 18th when the judge reviewed it. The next short matters hearing was coming up on February 26th. Okay? So this is for a C4 motion to dismiss, which is a sworn motion. Okay? It has to be reviewed and set. This is the review and it's being set. Now, the traverse has a timeline. The traverse that will rebut his allegations. That 10-page sworn C4 motion that says, look, I was in the back seat. I didn't know my license was suspended. I wasn't the driver. And if I wasn't the driver or eluding, then the count 3 fails because you guys were not exercising a lawful duty to arrest me. So that's what that C4 motion says. The traverse would have had to say, no, 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 no. We swear that, you were the driver. It would have been something like, we have body cam footage. We have positive identification. Officer so-and-so looked you dead in the eyes and saw you, when you turned left or something like that. So that would be a proper traverse or demur that would challenge that C4 motion. And it has to be done within 2 days of the
The
hearing.
hearing.
No, whoa. That has to be what? Say
It
that
has
again.
to be
done
filed
within
2
48
days,
hours.
2 days before the hearing
Oh my God.
in
And I
order
gave
for
them
it
the
to
extra
be
day.
deemed timely.
Okay, now wait. You said a demur traverse, right?
The demur traverse.
Those are the only 2 things, though, right?
Those are the
Yes, only
only
2
2
things
things
that can challenge that.
challenge a
C4
C4
motion.
motion. Now,
Oh my God.
likewise, a defendant only has the C4 motion as a pretrial defense to dismiss the case. Okay? So now, on February the 18th, the judge reviewed this and set it for short matters hearing. Now, I'm going to go ahead and give y'all a little bit of, you got to kind of read into and know the procedures and the potential traps, you know what I'm saying? Because this is chess, not checkers. So Marcus files 2 motions. The judge reviews 2
The
motions.
motions.
The state
8.
decides to set Marcus's PD motion for hearing. Again, two motions filed, 2 motions reviewed and set for a short matters hearing. The state opted or cherry picked only the PD motion for hearing. Now, I'm just giving you rationale. The reason why I believe that they did that is in the event if Marcus brought up the C4 motion at the hearing, they could say it was never set as a notice of hearing because it's Marcus's responsibility to set his motions for hearing as a formal notice of hearing. Are y'all all following that?
Yep.
Well, Marcus, you following that? Is everybody else following that?
Yep.
Okay. So notice of hearing has to be given. The state said, all right, we're just going to do the PD. In any event, if there's any fallback, we can say his C4 motion was never given a notice of hearing, right? Now, remember, we said this is chess, not checkers. So we knew the rules that they had to file a traverse within 2 days in order for it to be considered timely. Hearing is on the 26th. On the 25th, we did a motion to strike any traverse filed as untimely as the time per 3.190D was 2 days.
Dang it. Where's that at?
What?
Where's that at? No, but
3.190D.
where's the strike? Where's the strike, though? Is what I'm saying.
We filed it. If you need it,
I want to see it. I want to see it.
Give a sec. Give a sec. But we filed a notice to strike the state's traverse as untimely because it was due at least 2 days before the hearing.
Right.
Now, this is very, 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 very important. In that motion to strike, we state the C4 motion is to be heard on the 26th of February. Now, that's a pro se notice. That's not an official notice of hearing, but we should all know that pro se filings are considered to be construed liberally under Haynes v. Kerner, which is substance versus title. So we didn't have to title it notice of hearing. It just in the body of the motion, it had to say the C4 motion is scheduled for hearing on 2/26. Okay, so now we have constructive notice and actual notice. Constructive notice is when the court did the review. That's why that's why I keep saying that review sheet was important, because the state reviewed it. They had the option of striking it as a nullity, saying, nah, you're represented by counsel.
You're represented by counsel.
By counsel, this is a nullity, but they didn't. You know, in that review, they said, okay, we're going to set it for hearing. The same as his PD motion. So now, on February 26th, is the hearing.
Oh,
the judge says, what are we here for?
There you go, Cam.
Well, first, Marcus jumps in front of the podium and says, I'm here on the special appearance. The judge says, no, we're not doing that.
Don't sit back down.
Get out. Get out. We're going to call you back.
I was dying inside, bro. I already knew, because when he did that and forced the PD on me after I fired my attorneys, I came in there on a special appearance.
Now y'all remember. Y'all remember. Yeah, in the very beginning of this, he had private attorneys, y'all.
Yeah.
Okay. Then he fires him, says, I'm going to represent myself because these fuckers don't work. And they force a public defender on him. They're like, oh, no, dude. No,
and then
dude.
$15,000 later, $12,000 and $15,000 later.
You see how they work? They're like, oh, no, dude, you're not coming through and finna work your magic, man. These people got a duty to us. Okay.
Yeah, right. So we're gonna land the plane on this one. And you guys, I mean, this is gems, right? The reason why this is gems is because we have actual receipt. And that receipt says we have no substantial evidence that there was a crime committed, wherefore we had to drop them charges. Okay. At the end of the day, we all want receipts, we all want results. All right. So just follow along. I'm gonna land the plane, you know what I'm saying? But just follow along real quick, right? So they tell Marcus, nah, we ain't trying to hear that special appearance crap. Back off. So then maybe 30 minutes later, they call him back up to the podium. Marcus goes to the podium. Judge says, what are we here for? Marcus says, I'm here on my C4 motion, and I'm here to discharge counts 1, 2, and 3. The judge says, who filed this motion? PD confirms Marcus filed it. Marcus also says, hey, wait a minute. I'm also here to discharge my PD. And I'm here to give notice that we ain't never did a Ferretta inquiry. So the judge was so mad, screw face and all. He whips out his book with the Ferretta colloquy questions and says, Marcus, do you know that you have the right to representation? Marcus, what did you say? This is important.
I comprehend.
I comprehend. Not I understand.
Yeah, boy.
Not I understand. I comprehend. When Marcus said I comprehend, it's like he got mad.
His eyes got big. He leaned up in his chair and said, what did you say?
I comprehend. Do you know if an attorney is not appointed to you, the state can appoint one to you? I comprehend. Listen, every time he asks the question, it's I comprehend. So just write this down. It's I comprehend. I comprehend. Never I understand. I comprehend. All right.
I comprehend.
So that's very important. Always ask for a Ferretta inquiry so they can get y'all past that. You know what I'm saying? They're gonna ask you, hey, you know, have you ever represented yourself? Do you know legal this and legal jargon, this, that, and the third? At the end of the day, comprehend through it all so you can get to the bottom of it that, look, I want to represent myself, or I want to be in charge of my representation.
Okay, One sec. Jed, you got a question? Hand up. What's good?
Yeah, fam. So check this out. In 2010, well, stemming from 2006, I got raided. They kicked in my door and went through the whole motion. And then upon the warrant, right? And I want everybody to pick up on what everybody's saying because I see the room, right? they did a warrant. The police said that they called me 48 hours before they got the warrant, and I had a court-appointed lawyer at that time. That freaking lady, I'll never forget her name. Her name was, I'm throwing names out there, Elizabeth Dembitzer, bro. She's out here in Worcester, Massachusetts area. That lady tried to freaking process me civilly, and I said to the attorney, I says, listen, the court said that they called me 48 hours before they got the warrant. I could prove that that's a lie. Yo, you know what I did? There was only 12 phone calls within a 48-hour time span from the application of the search warrant, all right? So when the police say that they called me and spoke to me 48 hours before activating a search warrant,
it wasn't you.
That's your evidence right there. So you know what I did, fam? I went and I freaking found all of my buddies, because all of them were my boys, and I had every one of them give me a signed notarized affidavit. I brought them in the court. Guess what happened? The attorney didn't want to file my freaking evidence, and I said in front of the judge in that little question sheet that you said to the whole room, that's exactly what they did to me, and I wasn't the one that day. And I said, nope, Your Honor, I want to fire her right now. Right now, I want to fire her. And he's like, well, what's going on? He's like, Your Honor, listen, I got evidence right here. The police said right here in the middle of court, I stopped the whole thing. Brother, I was already in shackles. I didn't care. What was I going to lose? So I said, listen, 48 hours before, I've got full evidence right here, 12 signed affidavits, 12 incoming phone calls, 48 hours before the search warrant was issued. They said, okay, we got to put a pause. They gave me a Franks hearing. So I told them that, yeah, I'm capable of representing myself. They approved my Franks hearing. That freaking little side piece, fake freaking add-on lawyers that they give you. She's like, oh my gosh, I've never seen one get approved. And I'm like, oh, well, oh my gosh, thank you, because you weren't going to sign one. And guess what that lady did in middle of court? She had nothing to do. She was like had a tail between her freaking butt. You know what I'm saying? And I'm standing there. They gave me the motion. They performed the Franks hearing in camera. Bro, I lost it. I was like, not even the standby counsel, because they left her as a standby counsel when I did my full complaint. My man, they still held an in-camera hearing after the fact. And would you believe the judge upheld whatever the heck the police had going on, and I ended up doing 4 to 5 years federal prison, bro. And here we are today.
Damn, dog. Well, that if only if Wisedome was available.
Oh, man, don't do it like that. If only,
there's an angel out the sky.
Man, watch out, y'all.
Yeah.
Now, this ain't me. Y'all got to remember, this is the great creator, bro.
Yeah, no.
Y'all got to remember, this ain't me. This is the great creator working through us, because, again, I am you, and we are us, and we are all a part of this great I am, bro. And the great creator is coming back to the forefront, yo. You know, the spiritual realm is starting to really play out like it's supposed to play out. And the more that we recognize and know that we are true Americans with a duty, right? First off, we got a duty to respect each other, to respect the life that we've been given. You know, we are to live to uplift, to empower, with morals, and gratitude. And the best way that we can show the gratitude is by helping others in this life. And what I mean by that gratitude is gratitude to the great creator just for life in and of itself. And that's what it is, bro. It's not me. It's all of us together. It's truly all of us together as one. All right.
Yeah.
So on the screen, real quick, what I want to do is homeboy just sent me the defendant's motion to strike or disregard any untimely traverse to the defendant's rule, the motion to dismiss and notice of objection to late filed traverse. So he's putting it on notice. Hey, I know for a fact that y'all cannot play me. Okay. Don't play me. I know the rules. You asked me in this Ferretta, right? But I guess y'all was going through the Ferretta. So keep going through it. We'll get back to the traverse, I guess. Go ahead.
All right. So I'm just going to try to land everything right quick. So he goes through the Ferretta inquiry. Now he asks the questions. Now listen to what happens. He asks the questions. Do you understand? Do you comprehend? Do you understand? Do you understand? Do you understand? Marcus answers, I comprehend, I comprehend, I comprehend, I comprehend. Immediately, he says, all right, well, I find that the defendant waives counsel. All right, we're going to move towards pretrial hearing is going to be on such and such a date. All right, let's go. Get him out of here. Get him out of here. And rushed Marcus out.
Exactly like that. Got the bailiff.
Exactly like that.
Stopping me from talking on the record.
All right, gotta go.
And forcing me out the doors.
All right.
That's crazy.
That's crazy.
So let me give you the
objecting?
reasoning. Say that.
Did you consider objecting to the waiver of counsel? That's not a waiver of counsel. You can strike up counsel at a later date.
Right.
Yeah.
Yeah,
It's up
I
to you. I
object.
could have counsel tomorrow, no counsel the next day, counsel 2 days from now. I mean, it's up to you how you counselify yourself.
Well, that's
No.
why they really enforced the fact that they stated I comprehend.
Right. And that I also stated on the record that I have my Sixth Amendment right to co-counsel,
Self-representation.
to hire co-counsel, or, you know, represent myself in this manner of law. So he was kind of hot about that as well. Because I know I can bring on co-counsel. It's the law. You know?
Yeah,
I'm
yeah, yeah.
following within the laws. I'm going by the rules. I'm playing their game.
All right, y'all continue on. Go.
All right. So from there, motion is granted, PD removed, pro se status is granted. All right. So now, what ended up happening from that motion? The muzzle has been removed.
Right.
Now Marcus can speak.
I
You know.
we removed the jurisdiction.
Yeah. So now, what happened, which is crazy, because again, abuse discretion. Now the state in that hearing was present. The state did not object
Right.
to the hearing.
Nope.
Marcus brought up C4 motion
Motion.
in the hearing. Wherefore the hearing was heard. It was
Yep.
set. That's why I was saying it was important that document. The judge said it. Marcus did a pro se filing, which gave the notice. State was aware. State was there. It was argued. Wherefore, the very next thing is we need a ruling. The judge needs to rule on it. What happened? We brought it up at C4 motion, but the judge tried to kick it down the road. Now, right then and there, okay, in terms of appellate review, everything happened for the C4 motion. It was filed, reviewed, set, noticed, argued, right? So if there is no traverse at the hearing, everything filed in the C4 motion as a matter of law, not opinion or discretion, as a matter of law, right then and there is deemed true, right? It was sworn and it went through all the rankings, filings, and everything like that. So it's deemed true. There was no traverse. So everything ready for appellate review is stamped on the on that 26th date. Now, what the state did, which was maybe like just a couple days later, they had a hearing. And in that hearing, they told Marcus he didn't need to show up. But guess what? They still entertained the public defender.
Mm-hmm.
So the public defender was still making decisions on Marcus's behalf like 2 or 3 days later. So they set up plea negotiations and sentencing. They had a sentencing hearing. So Marcus was like, "What the hell? I thought I was pro se." So we filed 2 emergency motions because also they filed, or the state again cherry picked.
Yep.
Marcus's motion to strike untimely traverse, and they set it for hearing. They set that for hearing on March the 5th, which was maybe just a couple days later.
Yep.
So Marcus
Wait a second. In the strike that he filed, number 14, again, I want y'all to remember, is any traverse or demur filed on February 25th, 2026, or on the day of the hearing, February 26, 2026, would be presumptively untimely under the plain language of Rule 3.190D, at least 2 days before any hearing, and therefore subject to being stricken or disregarded, particularly where, as here, a late filing would cause unfair surprise and prejudice. Such a late filing would be inconsistent with Randolph versus Purvis, which recognized that a traverse filed after the hearing begins is improper. Continue.
All right. So now here's this. So I remember earlier, saying, given the framework, I told you that a C4 motion was a sworn motion. I swear this is what it is. And the traverse or the demur Okay.
Hey, what's going on now? Y'all got
I'm
that
out there in the sun.
sun.
I just needed
Yeah, I
a cold
know.
drink.
I know y'all
Okay.
damn.
Yeah. So the traverse is the only mechanism which is a sworn, you know what I'm saying, denial of the allegations. And that is the only vehicle that is prescribed by law to challenge the C4 motion.
Right.
So Marcus has a March 5th hearing to strike. Or his motion to strike untimely traverse is scheduled to be heard. The state comes with a motion to strike his C4 motion.
Mm-hmm.
They say we want to strike his C4 motion because it's not sworn. We want to strike his C4 motion because he was represented by an attorney.
Yeah.
You know, but remember when I told you that document review, the judge could have struck it as a nullity.
Yep.
But he
They said
didn't.
I was. Yep. But I was represented by counsel, but he didn't. He
But the
didn't
judge
want to
didn't strike it.
acknowledge that.
That's
He
crazy.
did not want to acknowledge his fuck up. He excuse my language, his mess up. He did not want to correct what he did wrong.
Now, do you think it was intentional? Or do you think it was that he just had so many cases that he just
No.
Okay.
They were both filed.
Yeah, they were filed.
They were both filed pro se, and they were both filed at the same time.
Yep.
And they say Marcus Sims at the bottom.
Right.
You know what I'm saying? So there was no mistake that if it was by PD or anything like that.
Right.
But then again, I mean, it was prepared so eloquent.
You dig, baby. Let's go.
Hey, they could have said, "Nah, only a lawyer could have prepared this."
I'm telling you.
And
Let's
the
go.
language.
Yep.
So, all right. So to land the plane, the state came with a motion to strike his C4 motion, and I just already explained to you the only proper vehicle is a traverse. So Marcus says, "Oh, okay." Marcus files a motion to demand ruling on the February 26th, because in our standards, we already had that motion, right? So we pop up with the motion to strike, and then we filed a motion to strike their motion to strike.
Right.
How in the hell are you coming? Listen, Marcus went up there. Hey, look, man. Marcus had his notes and all. Marcus went up there and said, "Hold up, man, that's an unauthorized vehicle."
You gonna come to the hearing with a motion to strike.
Right.
A C4
Marcus
motion.
says that's an unauthorized vehicle.
And it's unheard of, and it's unreal, and it's right in y'all rules. We're going by y'all procedures.
Well, I want to know how was these prosecutors responding? Was they pissed, or was they just like, he's hitting hard"? Like, what was their demeanor?
Oh, tell them, Steve.
Listen, on day one, when Marcus was doing the Ferretta inquiry, there was a mean stare down. Oh my gosh.
Yep. Okay.
Hey, listen, if we was in a parking lot,
yeah. I'm looking.
Okay, wait. You mean
I know you got a bar card anyway.
Yeah.
You mean practice law? So, anyways, I'm ready to get to that. But I'm
you mean like the Western? You mean like the Western music was playing?
Man, it was like, hold up, bro. What you doing?
Oh, actually, Cam, I'm going to get those videos over to you for those hearings.
Okay. Good. That'd be nice. That'd actually be really cool. Yeah, we can.
I got to ship them to you.
Okay, cool.
I got a question.
Go ahead, Joe.
So when you say this is the wrong vehicle, I missed the part. So you're saying that their motion to strike, your motion to strike, was the wrong vehicle?
No, their motion to strike the C4 motion.
The C4 motion. Yeah, they can only come through with a traverse. They can only come through with a traverse or demur, according to the rules.
Pull it back up, Cam. It's right.
They tried to come through.
You guys are deep in these rules and okay.
What?
Yeah.
We're in the statutory framework. We got to.
Yeah. I got you. Okay.
So for anybody, just to clarify real quick, if you are a defendant in a criminal matter, your only vehicle to dismiss the case pre-trial is a C4 motion, which is your C4 motion is your I swear. You know what I'm saying? And in that, you want to remove any element that would create the charge. For example, in Marcus's case, fleeing and eluding. The element of that charge is
You gotta be driving.
you have to be driving and in control of the vehicle and the decision maker of the vehicle, of the fleeing. Right? So that's an element. You have to be driving in order to be fleeing and eluding. For DWLS, driving while license suspended, you have to be driving, right? The three elements for DWLS is you have to know your license is suspended, you have to be driving, and your license has to actually be suspended.
You gotta have all three of them.
Yes. So an example of the C4 motion to discharge the charge, Marcus has to state, or Marcus actually was in the back seat. He was never the driver. So the C4 motion is a pre-trial motion to dismiss, saying, hey, I swear and affirm that I was in the back seat the whole time. The state has to do a demur or a traverse, and they have to say, no. We swear and affirm that we have evidence. We have body cam footage. We have eyewitness accounts, that he was specifically in the driver's seat. That's why it was important when we were showing the video, when the police officers pulled up, the car was already parked, doors were already closed, and all parties exited the vehicle.
Yep.
So, go ahead, question? Comment?
Is that C? This is Todd. I'm sorry.
Go ahead.
Is that C4? I'm in the state of California. Is that
Sure.
C4 motion the same here in the state of California, or
you'd have to look it up, because I don't know if it's called C4.
Yeah, it may not be called C4, but it's the same applicability.
Right, but there's I'm almost sure criminal rule of procedure.
Yes.
It's gonna, you know what I'm saying? It should be across the board. It could be titled differently, but the mechanism is exactly the same.
Yes. Hold on, Steve. So what Steve is essentially doing, okay, it's all the same. It's just finding which rules of procedure meet up with that as far as the pretrial dismissal is concerned.
Right.
Now, what Steve and Marcus have done is they have shown that the elements have not been met to make a prima facie case. Okay? That's essentially all it is. You can come through in actually different type of ways, do exactly what they're doing, right? It doesn't have to be worded the same, but the applicability of the elements being met is the same. The argument is the same, right?
Yeah.
Because what does the state have to respond by according to their rules? The traverse or the demur? Guess what the state answered back by? Like Joe just brought up. A motion to strike. That ain't sufficient, homeboy. Won't work.
Nah. Marcus went in there and said that is an improper vehicle.
That is an improper vehicle.
Improper vehicle. You can't do it. Sorry. Game
The
over.
eyes got big.
Game over. Matter of fact. Game over.
So
let's get into game over.
Here's the abuse of discretion, though.
Okay.
Tell them how they man, I'm gonna let me be.
Here go the abuse of discretion, though.
Yep,
yeah.
So the judge said, I ain't gonna rule on this right now.
Mm-hmm.
I'm not gonna rule on this right now because your motions were never properly noticed. I want you to do an official notice of hearing. So Marcus was like, well, damn. But what about that motion to strike? That's an unauthorized vehicle. You're not gonna strike that right now? No. I'm not gonna do that. But again, that goes to what's the gentleman down in Florida? My brother, what's your name? He was saying earlier,
King Willie.
Yeah, okay.
My name is Elie.
Yes, sir. Okay, the abuse of discretion. So earlier you were saying like, man, they never ruled and this, that, and the third. And man, that's so messed up. We were like, all right, bet. You know what I'm saying?
Yeah.
So now I'll take it that way as well. So that's a
Yeah,
good
like you
Yeah.
thing.
got to be like,
Yep.
all right, you know what I'm saying?
That's
Because
great. That's the greatest thing on earth. You don't
your
want them to
audience
move.
is not the lower tribunal. It's not the court, because the court is
Right.
going to try to abuse the discretion every way possible, spin you around. No, you didn't do this, and
Why?
that's cool, huh?
Steve, why? Steve, why?
Okay,
I feel
why?
what you're saying. I'm sorry to cut you off, but I've been dealing with this for a year. You know what I'm
Okay,
saying? A whole year. You know, and at some point, I mean, I'm not as young as you. I'll be 60 this year. So you know, I just want this thing over with.
First off, congratulations to
congrats,
making 60.
congrats.
Yep, for
Congratulations.
real.
Yep.
You know, so,
But
but
but hold on, Steve, why? Why is the
So
tribunal that way?
so here's this. The tribunal is worse than what you guys think. I want to let y'all know that off top. The tribunal, they're really gangsters. I mean, I just want I want you to look at it like that.
And they millionaires in there. They
Yeah,
all
I
millionaires
don't
in
want
there.
you to look at the
Hope, a
tribunal and the
hope, a
lower
hope.
court in the aspect of, oh man, these are upstanding people that went and got degrees, this, that. Bullshit. All right. I want you to see it for what it really is, so you can know how to really, really operate. They're gonna abuse their discretion. They're gonna abuse your rights at any chance possible, in hopes you don't know how to hold them accountable.
Right.
Okay. So I damn dog, because this is so intricate, and I want y'all to really, really, really.
Uh-oh. Uh-oh. Right when he was about to say the big point, he got removed. Y'all see how that worked? Damn. You see how that worked? Dang, that's crazy. They'll bring him. He'll be back. He'll be back as soon as he enters. He'll be back. But dang, that's crazy, bro.
Yeah.
Right when he about to get to his nice little point too. That's
Yeah,
wild. They took him out, Marcus.
I'm here.
They took him out, Marcus. Can you hear me?
Yeah, I can hear you.
Yeah, they took him out.
Oh man,
I'm telling you, right when he was about to make a strong point too.
he's gonna come right back from. He's probably gonna.
Maybe his phone died or something. Though.
Can you email it to him?
Come back.
He probably
I
jump on the laptop.
texted to him, but if not, I'll send him the link again to his copy invite link. Send it to him in text again. There we go. But yes, he is laying down how the inner court working is like a theater. They're administrative in their aspects, right? And that's why, Marcus sent me over. We're waiting for Steve to come back. That's why Marcus sent me over, Q-sips on this bad boy. Okay.
There you go.
Okay.
Now they're gonna laugh about this one, boy.
See what I'm saying?
Oh yeah, and that's the court case. Just to let y'all know, it's
but what's a
connected to the
Q-sip?
court case.
Okay.
Okay. Q-sip is a bond that they open on you.
Okay.
It's a financial bond that they open up when you first do time in their county.
Well, then they got one on me. They had plenty on me.
And you probably rich as shit and don't even know it. And you're entitled
I've been
to
down.
a percentage of that.
Yo, hey, listen, I think I was about to say something very serious and my phone died.
Yeah.
Yep.
Yeah, that's what we thought. We thought that same thing.
Okay.
It was like, okay, cool. Good.
All right, so listen. So this is very, 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 very important that I was saying, is that if you don't know how to hold them accountable, everything you're doing, even a like you Cam, you have the C4 motion and you have the motion to strike, right?
Right.
Very comprehensive, right? Looks like it was prepared by a seasoned attorney, right?
Correct.
Even something as sophisticated as that, if you don't know how to hold them accountable, none of it matters.
Yeah. So when they come through and they say, dismissed, and you just acquiesce, they already know they got control over you.
Yeah.
You don't know the next steps at all as far as how to
Well,
stop.
they're gonna deny everything, right? Until you prove to them that you know exactly what the next step is, right? And it was very important. My phone died. I want y'all to really capture back to where we're at, okay? So,
this is so true though, bro.
So the judge says, no. We're gonna kick this down the road. We want you to do a notice of hearing, right? Because you haven't really done a notice of hearing. But as you guys know, as of February 25th, we did a pro se notice of hearing via the motion to strike. Right. Haynes v. Kerner.
Right.
Which locked in everything for the 26th. But the court wants to pretend like we don't know that.
Right. Because y'all put in the motion, at least it was docketed on the 13th.
Right.
Then you got a response on the 18th.
Right.
And then because we see the order and it was dated by the judge on the 18th. And then that was supposed to be supported by the short matters hearing on the 26th.
Exactly that.
Okay, go.
All right, so here's this. So now the second judge says, nah, you got to go ahead and do a notice of hearing. So what does Marcus do? He does what the court said, a notice of hearing, right? He sets it for hearing. So now he sets his motion for demand for ruling because we have a demand for ruling now, right? Because we like, hey man, everything happened on the 26th. We have a demand for ruling. We have a motion to strike. We have a motion for limity. We have a Richardson hearing. We have a motion to suppress. We got like 10 motions, all fully comprehensive, ready to go to be heard on March 25th, right? The hearing is set for 3:30. Listen, hearing set March 25th, 3:30. What does the judge do? He denies all of the motions. He denies his C4 motion with prejudice. Right? Listen, he denies the C4 motion with prejudice. The motion is at 3:30. He denies it at 2:14.
How is that possible?
Oh. Who said that? How's that possible?
That's April.
Okay.
Oh yeah, it's April.
Okay, so you remember when I said they're gangsters? Y'all heard me say that before the phone died, right?
Yeah.
They're gonna do whatever they can to discredit whatever you got going on. They're going to overuse their discretion at all times possible, right? Only until you know how to hold them accountable, right?
Right.
So all the motions denied with prejudice, some of them without prejudice, denied. This was on March 25th. So now, not only do you need to know appellate rules of procedure, criminal rules of procedure or whatever case you're in, you also need to know appellate rules of procedure. You remember I told you the most important thing, Cam, is at the bottom.
Right.
We reserve all appellate review.
Cam's back in it. It's like nothing happened.
Right. So they just act like, man, ain't nothing happened. Right? So here's this. All the motions were denied. You remember that comprehensive C4 motion? Denied. Comprehensive motion to strike? Denied. All of the other documents were comprehensive. Denied. So you could have Johnny Cochran or whoever main attraction lawyer draft all your documents. The court is going to deny them unless you know how to hold them accountable. So what happened? Immediately, in order to get into the District Court of Appeals or appeals court, you have to give the court a second option, a second chance. So we did a comprehensive motion for rehearing only to give them an opportunity to try us again. So back to King Willie. You remember when you had that bad news? Man, they don't want to answer the rules. Right?
Sure don't.
Yeah.
We say bet. We love it when you don't answer the rules.
Because we're gonna take it to the DCA.
We love it. So
Yeah,
so what
well,
we did,
that and the fact that again they're violating their own rules, y'all.
Right.
Yeah.
Right.
They're literally
Within their
violating
four
their own rules.
corners.
Like y'all
Within
got to
their
play by the
framework,
rules. You're not
they
playing
are
by the rules.
violating.
And then what does that lead to? It's just straight up like Lori. What happened with Lori? They didn't play by the rules. So what happened? Lori called
Prosecutorial misconduct.
prosecutorial misconduct. Oh, Lori's in here. Hi, Lori. Miss you, girl. Okay. They don't play by the rules. They're just going to scapegoat themselves out. Oh, well, we would be willing to drop this dismiss this in the interest of justice. Then you see what I'm saying? Like literally, that's what the snail sounded like. I don't know if homeboy's phone died again or he just dropped out. Where you at, Steve? You drop out? My boy did drop out for real. His phone, his charger ain't supporting his phone right now. Apparently,
Yeah, something's going on right now. That's that blessing they're trying to stop that blessing coming
trying
out.
to start.
Yeah.
They sending extra waves to kill my boy's connection
Yeah, I'm
right
telling you,
now.
what? They're trying to keep him drained over there.
For real.
Recording in progress.
I really want him to end up coming back to where he finishes off the story. But you can continue right now if you want to.
Right. So what I will tell y'all is that after
Where was we at? He was like,
the 5th.
They did the strike. Y'all gave them another opportunity by rehearing.
On
That's
the
where he
5th.
pretty much left off. Yeah.
Right. So on the 5th of March, we went to the hearing, and I told the judge that I wanted my C4 motion to be ruled on. And the state came with a motion to strike, which is an improper vehicle, according to rule 3.190D. There must be a traverse or a demerit to go against a C4 motion. That's just like you got a rabbit going against a bear. That bear's finna, he's finna eat him. He's finna grab him. He's finna claw him. The rabbit doesn't have a chance if the bear just lay down on him. If he sits there and let the bear lay down on him, he can't do nothing. So that's what position they was in. I was just sitting on them because they came with a motion to strike. That's an improper vehicle.
Yep.
That's just like trying to put a car between a motorcycle bar.
Yep.
It's not gonna fit.
Right.
So the judge, he would not rule on the motion because he was not the original judge of the charges. Now, he set it for hearing the proper way. When it was set for hearing due to me filing, what I filed? Due to me filing my traverse on the 25th before the 26th hearing, I stated in my traverse that my C4 motion was to be heard at that hearing. So they had actual notice and they had constructive notice. And I had also set my C4 motion for hearing due to my filings. So the judge, he did not rule on my motion. He did not strike their motion to strike. Yeah.
Hey, I'm back, y'all. Hey, listen.
Okay.
Hey, I was
Get
on
to
one.
it.
I was
Yeah.
on 1%. But listen, I'm telling you, listen.
Yeah, it's
This
fire.
is a wild.
I got to write a book on this.
Man, listen. This is wild. I want you guys to really be engaged and soak in all this information because this is gonna help you guys on
We
all of y'all
are.
cases.
We are. Let him go. Let him keep going. Go, Marcus.
Yeah.
Now I'm gonna let Steve better explain it to you.
Okay.
Now
Well,
that he's back in,
you know where
let
he
him
just left
continue.
off, Steve, or no?
All right, just give me a little nugget right quick.
We were at the hearing on the 5th.
The hearing on the 5th. Okay, the hearing on the 5th.
Also,
basically, go ahead.
Let them know when I objected to the judge what everybody did in the courtroom.
Oh, listen. oh my gosh. Listen. So the judge, Marcus went in and he objected to the judge, right? And he was like, "Hey,
wait,
you're gonna object to the judge?"
Go
ahead.
What for? What did he object for, though? You got to give us that.
Okay. So the state was trying to say that they're there for a motion to strike, right? So Marcus was like, "Object." You know what I'm saying? How y'all here for a motion to strike? That's an improper vehicle. So the judge was like, hold on, wait a minute. Well, let me tell you, Marcus, you really need, he said, Marcus, you need to go ahead and set this for hearing. And Marcus was like, hold on, object. And he was like, well, wait a minute, how are you gonna object me? I'm the judge. You're just gonna object the judge? Yes, and then everybody started laughing.
For real. Everybody.
And I was like, man,
it was
look,
court reporters in there, cameras in there. They're all laughing.
Man, I'm gonna tell you this right here, man. To be honest with you, and I'm gonna take a time out real quick, and I'm gonna go back to kind of what you were saying earlier, Cam. Thank you, my love. Thank you, Cam. Earlier, you were saying like, look, man, it ain't really about me. You know what I'm saying? It's like this environment, you know what I'm saying, exists so that we can all learn and this, that, and the third. I will tell you, a very proud moment for me was to be there with Marcus.
Yeah.
Because this is his case, right? This is his whatever. But it was an honor to be there because in that arena, everybody laughed. The judge.
You want to know what's so great about being in that arena?
Yeah.
What is the arena of? It's an arena of intellect.
Right.
Really think about that.
It is.
It's an arena of intellect.
It's an arena of intellect, right? So while everybody was laughing at Marcus, I was like, bro, man, you did a damn good job because you were not entertaining the lower tribunal. Back to what Joe was it Joe Ellis? Joe Willis? Joe Ellis?
Joe Ellis.
Yeah. Joe
Ellis. Listen.
He says it's so together though. Joe Ellis.
Right. Hey, but listen, you know what I told Marcus? You weren't entertaining the lower court. You were entertaining the appellate court, bro.
Yeah.
That's right.
When you did that objection, that shit was right on cue.
Yep.
Right on point.
Right.
And I told Marcus, I told Marcus when you left, I gave you a B, right? I graded you a B because listen, I'm gonna tell you why I graded Marcus a B. Listen.
It could have been an A. It could have been.
It could have been an A.
I got one.
I'm keeping it real all across the board.
Yeah.
When he was in there, he was titling his C4 motion as a traverse.
Oh, okay.
No, but listen.
Okay.
No, hold on. I got to come back from my boy. He had his notes. The minute he went to his notes, he was like, hold on, wait a minute. This is an improper vehicle. I object. Man, hell no. We done did this on the 26th. We done filed an untimely traverse. Listen, he had his notes down pat.
Yeah.
You know what I'm saying?
Yeah.
So it's like he fell off at the beginning, this, that, and the third, probably because a little bit of nerves or whatever. But when he got on point, and this is what Wisedome is. This is what this is, right? So that we can all focus and get each other to know when to get on point. Everybody in this chat done been to court before. Probably even done been in jail. You know what I'm saying?
Yeah.
Everybody done been in jail. Cam went to jail the day he left my house.
That show's my good too, bro.
God damn, Cam. I say, oh shit, Cam know how to speed it.
Got locked up.
Bro, I was just sitting on the side of the road, bro. I just needed to take a piss real quick, bro. I swear. I swear, bro. All I had to do is take a piss, bro. I don't know what happened.
Locked up leaving the crib. But here's this though, right? Everybody has been in this situation where they would have benefited from having somebody to be like, nah, bro, you good. You know what I'm saying? And when Marcus was up there, he fumbled just a little bit. He got back on track. As soon as we left, I said, listen, you remember when everybody was laughing? You preserved the record, dog.
Because that's what made me feel bad when they went to laughing. And I'm talking everybody. Everybody, the court reporter, the court
whole
typewriter,
courtroom.
everybody. I looked everybody in there. I looked around at everybody laughing.
Everybody was laughing.
Laughing. But this what I would tell you, not to cut you. Remember when we was in the first hearing on the 26th?
First hearing.
Remember the state attorney that was over there with the other state attorneys?
Yep, the two ladies.
Remember when I went to talking to the judge how she was looking?
Yes.
Tell them how she was looking and what she was doing.
She just was, hey, listen, she was like, give it to him. Give it to him.
Yeah. And this is a state attorney.
Yeah.
She's like, ain't nobody never came in.
Nobody challenges. Everybody's scared. You know what I'm saying?
You know,
And here's this.
Before just keep going, I just want to say with Marcus, that's why perspective is everything. Because while one may view that the laughing as a negative, another sees it as a positive.
Oh, it was 1 trillion times positive because he was preserving appellate.
Yeah.
Review.
Well, I ain't gonna lie, my feelings was hurt.
That's what I'm saying. Perspective is everything, bro.
Yeah. Yeah.
So
I want to say
I had to tell him that immediately. I was like, bro, all those you did. He objected twice. I said, bro, when you objected twice, bro, you kept the appellate review. You did good. I said, bro, don't even pay attention to all that laughter, because again, you remember when I said the lower tribunal, they gangsters. They're there to discredit you. They're there to abuse discretion. All that is intimidation. Please, if you guys are in here in this chat, understand the court is not your friend. They are there to abuse discretion. They are there to intimidate you 100% of the time. Not only when you walk in, not only when you get to the podium, but 100% of the time. All right. So to land the plane, let's just go forward to where we hold them accountable. And this is where the receipts come in. All right. Everybody, this is where the receipts come in. So March 5th, Marcus was holding his objections. They laughed at him. We left. Bro, great job. We complied with the court. We filed a notice of hearing. I already told you March 25th, hearing was at 3:30. About 10 motions ready to go, drafted comprehensively, right? All motions were denied. And again, like King Willie, man, that was so whatever. In our eyes, bet. Immediately, we filed emergency motion for rehearing. Now, you guys have to understand how appellate courts work. You don't just appeal the judge's decision when they deny you the first time. You have to give them a second chance. You have to draft a motion for rehearing.
Now, let me ask you this too, though.
Go ahead.
Also, you can do like you can request or ask for or compel a formal written determination on the order in relation to factual findings and conclusions at law, or at least cause an issue to where you're stating that how can I defend myself under 14th Amendment? So I guess we're going more towards constitutional framework, but yet the due process allows for one to understand the denial of said motions, right? Through
you don't want it.
Okay.
You don't want it.
Well,
I'm gonna tell you why you don't want it. I'm gonna tell you why.
Go ahead.
Because you're still trying to get it in the lower court.
Yeah, I know. But again, that what's amazing is you're still using the process of their rules of procedure. You're still getting a violation of the canons as well, because the judge has a duty, again, to give an order with factual findings and conclusions at law in relation to why the denial was given in the first place. That's just another. Just let me let you know.
No.
That's another leg to stand on. You dig what I'm talking about?
No, you're absolutely right, because that
You have to understand. Wait. You have to understand the state's theory.
Right.
If you don't understand
you're correct.
Okay, go ahead.
No, you're absolutely correct. You're absolutely correct. And honestly, I'm just trying to fast forward, right? But what you're saying is, honestly, what you're saying is you're giving them an opportunity to give an extra layer of exposure.
No. When I'm asking,
go ahead. I'm gonna explain to you why is that.
Let me hit you on the shorter one. I'm stating that once you get the denial, you're supposed to, once compelled or requested by matter of right and duty, to get them to give you an order, okay, written out, which is what this is one of the first things I learned, bro, back in 2008, 2009, when I got the first.
I'm agreeing with you.
Okay.
I'm agreeing with you.
That I need to understand the theory in which you're why you're denying what I brought forth, when my comprehension and knowing is that I have a right to travel. Okay.
All right.
If I've brought something forth in the memorandum and affidavit form with points and authorities, and I'm stating that I am requesting, wherefore, that you give me an order based on this information on why I'm wrong, then you must provide it. Period. Right. Findings of facts, conclusions at law. If they don't give it, that's a violation, bro.
So check this out. So what I said shortly and earlier is automatically know they gangsters. Automatically know that.
Yeah.
What you're saying is I want to assume that they are upstanding and they're going to give me this ruling.
Now check it out. Okay, now check it out. We have actually had some really great judges. For example, in Arizona, for example, in Arizona, Shane, he went through a trial. Okay, and he had DOT plates on. The trooper admitted that he didn't have access to be able to search the safer system to determine whether the DOT plate was adequate or not, right? If it met the standards of being official or real whatsoever. Right. Shane did not do cross-examination. He did an opening statement and he did a closing statement. That's it. He did not participate in cross-examination. Right. He said his paperwork stood enough for what he needed to say, which was sworn. Okay.
Right.
When the judge comes through and gives his opinion on the lower side, which of course he moved in favor of the state, but when he came through, when he made his closing remarks, he stated, "I really wish you would have argued this out today. Your pleadings are so substantial that I wish everybody knew, and this element of comprehension was taught in elementary schools."
Wow.
So when I say there are some good possible judges out there, you know what I'm saying, that's willing to give the chance. I mean, I've witnessed them. I got some good ones. I've got some that have laughed at me and joked with me. And when I've spoken of necessarily like Haynes versus Kerner, right? And I'm out here
right.
I need y'all to take everything liberally. Listen, Mr. Wilson, we are. So let me actually explain it to you then, right? And come through and be as polite as possible and break it down. So, I don't want to say all of them are bad, but there are some.
Yeah. Hold on. You know what? Let me rewind. I will say this, right? And I agree with you, Cam. Matter of fact, I'll speak to everybody in this group. When you guys go to court, don't treat the judge like he's a mother effer. You know what I'm saying? Because the judge is going to react off of your energy.
Yeah.
Now, Marcus, I don't know what type of. I'm looking at your paperwork.
I mean, if the judge come hard at me,
yes,
I'm gonna kind of let it slide off my shoulder and be like, oh, okay. Well, I thought, that, like, if I'm not mistaken, right? Like, you see what I'm saying? Like,
right.
Like, if I'm not mistaken, I thought that based on. You just reverse it right back to intelligence and intellect.
Yeah.
That's it. Because you know where you stand, but you have to know it.
So here's this, right? I've seen like a lot of people go in with this living man, sovereign, I run the court shit. And I will tell you, that's probably not the best attitude to go into court. You know what I'm saying? When there's court, that's fine. Like, I wish that everybody knew to just disarm, like, you know what I'm saying? Like, obviously on the side of the road, you're dealing with a cop, you know what I'm saying, it could be a tussle, right? But I would say do not stay in that frame of mind, because all of this stuff honestly is administrative paperwork that can go away, and it will go away a lot faster if you guys have a positive mindset and just use, you know what I'm saying, like these administrative tools that you guys can learn here first. Like just use them. You know, these judges are like, I mean, they could be as gangster as you want them as they can be. You know what I'm saying? But if you stay in your administrative posture as like, all right, I just got to file something back. Whatever I get that I don't like, I just have to file something back. If that mindset is there, man, you guys will probably win all of your cases.
Okay. Now, what they did is they dismissed all of the motions. You said that's
Right? They
counsel.
denied. They denied
Okay.
all of the
Okay.
motions. All right.
Okay. Go from there.
So let me land the plane.
Yeah.
Okay. So here you go.
Oh.
Oh. Here you go. So now they denied all the motions. We do
All the
motion for
motions.
rehearing. And what did they do? They denied the motion for
Denied it.
rehearing.
That was the
Bet.
best thing ever.
Bet. Thank you. So now the weekend
Now we get to
hits.
go to the DCA.
So here go Monday. Monday is sentencing. Marcus goes to the hearing for sentencing
On the 30th.
on the 30th. Right?
March.
They're like, man, look, we ain't trying to hear this shit. We're moving forward with the case.
With the case. Forcing me to trial.
Well, yeah, we're going to trial. Everybody, yeah, we're doing that. Marcus goes to.
Oh, also told that anything that I file is going to be labeled as frivolous.
Yeah, anything you file is going to be frivolous after that.
And I can't file nothing.
No problem.
Yes.
Marcus goes to Daytona, to the 5th District Court of Appeals, files his writ of mandamus after the hearing.
After the hearing,
March 30th, goes to his hearing was at 8 o'clock. Marcus files his writ of mandamus at 3:30, 5th District Court of Appeals in Daytona. March 31st at 1:38. We drop all the charges. We don't want no smoke.
The next day.
The very next day.
Very next day.
We don't want no smoke. We don't want no smoke. We want to discharge fleeing and eluding. We discharge DWLS. Do y'all think this happened because they just changed their minds?
No, you held them accountable.
Or did we hold them accountable?
You held them accountable.
You understand? So this goes to King Willie. When you get those notices that are unfavorable, say bet. Let me hold you accountable because you were supposed to do this. Let me preserve my appellate posture and take it to the DCA. Now, I'm going to tell you what they don't want. They do not want to give you a case precedent. You know why? Because you become Willie versus State.
Right.
2nd DCA, 5th DCA, 3rd DCA, ... and your name lives forever.
That's what I want. That's what I want.
They don't want to give it to you.
I know that, but that's what I want. I mean,
they don't want to give it to you.
I just want to say this. I mean, as I say, I'm almost 60 years old.
Right.
I've been telling the same story. I remember when it was a time that the police, you was able to do anything you wanted to do because I experienced it. But when they put all of this other negative stuff on TV or whatever to brainwash people to say, oh, it's all right to come in contact with the police, that's when I noticed the change. Because as I said, I was in a situation where, you know, something like Donald Trump, I had 32 felonies and beat them all except for one. Because there was nobody injured and nobody came to testify at the grand jury. So that's why I believe in what I believe in. You know,
so just quick question. So you challenged the jurisdiction at the grand jury?
No, I told what happened was I just went to the grand jury. I had 32 times. But the state in New York, they had Lisa 180 days to come back again. You understand me? And every time they never came back again, I kept going back for each charge. And I got everything dismissed except unauthorized use of a motor vehicle.
Now let me ask you real quick, y'all, on this nolle prosequi. Like, how did you get this notification? How did you end up finding out about it?
Let me tell you what I did.
Okay.
I went to file what I couldn't file in the DCA because they told me I needed to go file it in the lower courts. And what I could file in the DCA was the mandamus. So they took that and told me the petition?
Yeah, the emergency motion to
Emergency
stay.
motion to stay.
Yeah.
Right. And I needed to change the headlines to the lower courts. So I went to file that in the lower courts 8:30. Well, early that morning. It was
Hey,
about
what they told you, Marcus?
I'm finna get to it. Let me get to it. I went to the clerk of court, right? So, I'm on the floor. I went and filed that and had it certified and had it notarized. I always do it at the clerk of courts. So I went to go to the North Wing to go upstairs to the state attorney's office and the JA's office,
Okay.
which is the judge's assistant, right? So before I can get all the way around the corner, I'm telling you, because if you see the inside of this courthouse, you would be laughing. So I left the clerk's office and I have to go back past the entrance where you come in at. Straight cross. It's just right cross. When you turn right, you see a group of people all the way down, probably like 4 courtrooms down. You know how they're split apart.
Yeah.
4 courtrooms down, there are a group of people on your left side. I'm on the right side as I'm walking down. And they're just standing there and they're all talking. But as I got closer, they all shut up. They all got quiet. Bro, I'm wondering what's going on because I got to go past them and turn left. Actually in front of them, and I got to turn left right in front of them to go
Bro,
to
I
the
can
elevator.
no cap. I can only imagine what you was truly going through at that very moment, bro. Like,
oh my gosh. So I'm looking at the crowd, but I'm not looking. I'm kind of trying to look where I'm going at, but I'm not looking at them because I got to go and turn left in front of them.
yeah.
The only one I spotted out of all them was the JA, the judge's assistant. Her eyes were big, like this, through her glasses. When I caught eyes with her, and I hurry up and turn my head, so she know I'm coming to serve her some papers. Now I know she's not in her office, so I go upstairs first.
Mm-hmm.
I pass the state attorney and go to her office.
Mm-hmm.
I go in her office, the door shut. I go over to, the little area where you drop the papers off. She's not in her chair. I already know that because I just saw her downstairs.
Right.
Now, I don't even leave the paper there. I'm like, man, at this point, fuck it. I'm finna go back downstairs and serve you in front of everybody.
Right.
I'm fucking tired of this shit. So
Right.
I get to the door. I'm looking down at my phone to look at what time it is. And I open the door. So as I go out the door and I lift my head back up, here comes the whole crowd that was just downstairs.
Right.
The whole crowd. So my
Right.
mind is like, what's going on? And she's in front of them.
Damn. This is
So
wild, bro.
I'm like, I'm handing the paper out. I'm kind of trembling a little bit. I'm like, what the hell going on? So I'm handing the paper out, like, well, I was just here to serve you. She was like, oh, you're talking about that Fleetwood Lou case? That's been dropped. That was no lacrosse. I was like, what? She's like, yeah. And also the state amended the third charge. But we're just gonna drop it anyways. There's no court date, so you're good. And I'm like, what? I still handed her the paper, and I was like, thank you. You're the greatest. And I hauled ass.
Yeah.
So yeah, so I hauled ass. I
That
ain't
is
even
wild.
served the state that paper, but I still hauled ass though. But they got it anyway. So
Okay,
comes
no.
now.
Okay, go ahead.
So comes now. This is what I meant to tell you.
Okay.
I want to say on the 2nd, the state filed charges again for the 3rd count, resisting without violence. Right.
Okay.
So they filed
the 3rd of April.
No, of
March?
yeah, April.
Oh,
April.
so just
The
yesterday?
second. Yeah, the second.
Or 2 days ago?
Yeah.
Oh shit. What's up?
So we filed another C4 motion stating that even if the facts that they are stating is true, no crime has been committed.
Right. Right.
You know, so and not only as that, this is still in the DCA
Right.
to dismiss count 1, 2, and 3.
Right. So
So
they have or they haven't given you an answer back?
they haven't given an answer back. I seen on the docket a judge review, but I'm waiting on it to be unlocked. So probably Monday it'll be unlocked.
Okay.
But what they did was they set a court date for I think the 15th or the 16th. I'm gonna go in there and look.
Well, I mean, I'm looking at the nolle prosequi right here, and it says comes now the state of Florida by and through its undersigned assistant state attorney and enters its announcement of nolle prosequi against the defendant Marcus Jermaine Sims in the above entitled cause based on the following grounds. In the light most favorable to the state, there is insufficient evidence to prove one or more elements of the crime charged. This was dated the 31st of March, 2026. I hereby certify that a copy of the above has been furnished to Marcus Sims and the Lake County of all by hand or mail delivery. William M. Gladstone, the state attorney, 5th Judicial Circuit of Florida. Okay, by Devin Razzie, however you want to say it, assistant state attorney with a certificate and what color of ink signature? What color of ink signature? What color of ink signature?
Blue, 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 blue.
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 Yes, it is. Yep. Blue.
My nigga. Damn. You done did it. You done did it, Marcus. Yo, I want everybody to unmute and let Marcus know. And Steve know, congratulations for real, bro.
Yay,
For real,
Marcus!
bro.
Congratulations, man.
Hey, but
Awesome job,
I give
Steve,
thanks.
helping them.
I give thanks
Congratulations.
to the
No,
Most
stop,
High
Marcus. Let
for.
everybody say congratulations. Everybody unmute and say congratulations to Marcus. Shut up, Marcus.
Congratulations,
Congratulations, Marcus.
Congratulations,
Marcus.
Yeah,
Marcus.
Yeah,
Super
Thank
awesome
good
you.
job,
work.
man. For
You did
real.
an awesome job.
Thank
eat
you.
Good
this up,
word.
baby.
Way to
And
stick
then
it to
everybody
them.
That's
Congratulations,
right.
Marcus.
What does the
Thank
blue
you.
ink signify?
Stand on their necks, baby.
What does the blue ink signify?
Royalty, trueness, that black can be rectified, like replaced, copied, right? I know it holds some significance. I think in a lot of everything that I would have to get it back to the reference of why the blue ink is so important. Again, I forget even of itself the direct reference of it. But Joe, do you have a direct reference to the blue ink and its significance right now?
Thank you.
I've read
Pull it up. Try and
about
pull it up
that
real quick.
between red, black, and blue ink. I forget the exact
Me
references.
too.
It might have to do with royalty and blood, red being blood and all of that. But the way I see it is that blue ink is at least shows that it's not a copy or anything like that when you're actually at a court of law. So everything that we've authorized is and put our autograph on is in blue ink, just to as further evidence, because you want the original certified notice when you have to go take it to court.
That's what I would think too. I'm trying to. I can't remember the exact reference. There's so many things. That's not something I remember, but I know that it sticks within the subconscious of being of great significance or at least importance.
Yeah.
I signed my notary public in blue.
But I'm gonna see right now, see what I can find real quick, and then we'll keep going. But Marcus, you had something to say after you had your congratulations. So what's good? Oh, he's gone. Yeah.
I don't know if Marcus is gone.
Steve,
but
everybody give a congratulations to Steve too, because
Steve, you too,
through
buddy.
Wisedome and Steve, you know, everything kind of manifested this greatness.
Thank you,
So
Steve.
congratulations, Steve.
Congratulations, guys.
Steve.
All right.
Steve,
Shout
awesome
out to
job being
Steve.
there for Marcus, man.
I was
yeah,
trying to
man.
give out my
Yes.
blessings,
Hey, I got a question
my
for y'all.
congratulations
Yeah, go ahead.
to
Go ahead.
Yeah, so
Cam and Steve, you know, for producing this amazing scenery right here. Without y'all, man, this would not have been done. As well as Steve, I thank you, my brother, for leading me in the right direction on my propaganda and how to honestly speak. As well as Cam and Steve, man, y'all both angels. Um, the Most High has put y'all in my life for a reason, and what's meant to be cannot be changed.
Right.
You know,
I
so
think
now,
we do have full control of our future now. I think
right?
honestly, there's enough of us to sit here and say, look, man, let's just really get to the point here that the intellectualism of America is about to rise like no other. Y'all have given us AI, okay? We now have AI. You cannot stop it, and since you can't stop it, there's no way that you're going to stop the intellectualism from continuously growing. Okay, so let's work together, understanding that the intellectualism will rise and that you will no longer have control and power and dominance over us as you see fit anymore, due to the fact that people can see the power that they have retained within them and know the morality of the importance of life, liberty, and the pursuit of that happiness. Okay, it's getting serious. So if we come forth within this next, I would say 3 to 6 years on some full representation type vibes, with a full mission statement, my nigga, coming forth to say we are rising the intellectualism of America through AI and supporting each other's life, liberty, and the pursuit of happiness with the most utmost respect. Watch what happens to America's culture then, bro.
Man,
Watch.
they're gonna want to stop the AI assistants.
They
If they
can't.
want to, they
They
can.
can't. They can't. They already speak about that in AI. They're like, bro, you started a machine that will not stop. There's no matter what you do as far as enforcing, you have to stop the whole fucking internet. And I don't even think stopping the whole fucking internet is going to happen because these motherfuckers got radio waves type shit.
Yeah.
So it's like it's light waves and all, like, so it's really, it's awesome.
Yeah.
We there, bro. Let's
So
lead it.
here's this. This is why I felt like, I ain't gonna lie to you. The whole idea of being humble, man, fuck that. Listen, with Marcus's W, that's a receipt.
Yeah.
You know what I'm saying? And that receipt was gained. You know what I'm saying? Hopefully everybody was here through this chat and heard. Look, with the most articulable motions and documents filed, the court abused its discretion and tried to go above and beyond. So hold on, wait a minute.
11 years.
Hold on, check this out. I made mention that they denied.
Wait, he said 11 years. What do you mean 11 years?
Marcus was facing 11 years.
They were trying to give him 11 years?
They were trying to give Marcus 11 years.
Damn.
What? Yeah.
Another everybody unmute. Congratulations, Marcus.
Years, bro. Hell yeah.
Congratulations.
Yeah, you dumb.
I got
That's
a
the making part. 11 years. Yes, congratulations.
Amen.
Let's go, Steve. Let's fucking go, Marcus.
I got a
Like, for
technical
real,
question,
bro.
Cam.
So here's the most important thing.
Fuck, bro.
Kane said earlier, this sounds like a remedy. In actuality, this was exactly a remedy.
Right.
You know what I'm saying? So it's like, copy this down. Understand the court is gonna abuse their discretion every single time, even if you're right, and even if you come with the most articulated document. That's proven here in this case. But the fact that we were able to hold them accountable immediately, like I said, within 24 hours of filing documents in the DCA, they were like, hell nah, we don't want the smoke. Let's go ahead and drop these charges in hopes that, like, they don't peep what we've been pulling. You know what I'm saying? The strings in the background.
Within like 15 hours, actually.
I have a question.
Go ahead.
Willie,
Go ahead.
what's up?
All right. Now, I heard your situation. He had a driver's license before, right, in the state of Florida, right?
Right.
Okay. So my case is a lot different. I've never had a driver's license in the state of Florida. I've never had one here in the state of Florida.
But let me ask
I'm
you.
trying to.
Let me ask you though.
But
Did you ever have a driver's license though?
Yeah, when I was a young man in another state, New York.
Okay.
in New
Okay.
York,
But listen, they're all the system.
Yeah, I
So when
understand.
they run,
Literally fire. Gotta
they
get
run
rid of
that
it.
name, it's going to go through their system and tell you, and it's going to tell them where you had a driver license at. So they're going to treat you as you have a driver license.
okay, so check it. So check it. Just for the sake of ending the recording, right? I just want again to I think we've seen the process, we've seen what they went through. It was procedural, right? What we see is you know, heads coming together, doing a lot of research, understanding the importance of AI and tools, conjoining those tools to be able to educate oneself with knowledge and empowerment, to be able to articulately take that in and know the knowing of yourself and the power that you have within for certain elements and a duty that certain things have to be done. And even on a lower administrative level, how one can still seek remedy even after decisions are made that were improper in the first place. Once one is able to articulate that and lay it out, you can see how the results are given, right? Because of those violations. I think what's really important here is that working even on a procedural level in this form or fashion is really cool because again, you're holding them accountable, and most don't hold them accountable. I think this is just a great victory. You know what I'm saying? Thus far, I think it's one of our biggest successes and victories within Operation Wisedome. And the reason being is just so much time, first off. Secondary is the fact that it comes with, you know, someone who was persistent, bro. Like Marcus literally went from I'm putting my faith into somebody else, right? As far as representing me, paid two different attorneys, came out saying, fuck all that, dude. I guess I got to do it myself. And did it himself, bro. And literally did it himself. Regardless of whatever may have happened in the background, dude came up in front of that court and did it himself. Okay.
Yep.
And that's powerful, right? Because he's never done that before. So he just empowered himself and his family and all generations to come from now on, bro. In every situation that he encounters in life. Everything in life, bro.
The people around him are so lucky because he can teach this to them.
Exactly. They're set for life, bro.
Yeah.
And that's
Can you say
what
that one more time?
bro, it's not just Marcus, bro. It's everybody that's involved with Marcus in every single form of life. No matter what you deal with in life, as far as a wrong is concerned, you will get remedy. I mean, I don't know if anybody's been trying it, you know, recently like I have. I've only had one incident recently that I had to do it on. But like my refrigerator went out for 2 weeks upstairs here at home. They spoiled some food. I asked for a certain amount back with a notice in demand, you know, after a certain amount of time. They immediately said, we're paying your whole next month's rent. Don't worry about it. It's on the books, on us. Sent one notice in demand within 24 hours, got my next month rent paid free. All they did was cite some rules as far as tenants' rights that I'm supposed to have as far as y'all being able to do things in a timely manner. So in every form and fashion in life, you can apply this. That's what's cool. Just learn the law, just a little bit.
Yeah.
It's about life. It's about life. If we treat life like the courtroom, hey, we're spreading truth, light, and getting rid of all the darkness and shadows and teaching people.
Got to get my liberty, bro. So
that's right.
I want to say, Steve and Marcus, do y'all both have anything that you would like to say in closing of today's Operation Wisedome?
Man, I think I'm very appreciative of the opportunity, you know what I'm saying, to be able to give receipts. Did you show him the
nice shirt, bro?
Dude, I
the
have a
nolle
technical
prosequi?
question.
Yeah, y'all want to see it again? Share it one more time.
Yeah,
hey, while you're pulling that up, can I ask a technical question about the objection? So earlier when he had reserved those two objections that made people laugh, I didn't hear you address or if anyone had mentioned like what the objections were. Did you get specific about the objection?
Well, yeah, that the judge was just denying, right?
No, I mean
So
just
the
words on the
objection,
record, like a sentence of word. I don't know if he got to say anything about it, or if it's just like objection, and then he shut him down and made everyone
What was
laugh
the
and all that
reason
stuff.
for the objection?
Right. Thank
so
you,
They went
Bob.
through that.
Thanks, man.
what the state was trying to do, the state was trying to, I guess,
They was trying to.
effectuate. They were trying to
But there's a
reason the. Go ahead.
Freaking God.
real quick. I'm sorry. Hang on. So I think Danny, what you're asking is there's an objection followed up by objection hearsay or
Right.
whatever the
Objection.
reason that you
Yeah,
objected.
irrelevant.
Yeah,
Objection.
exactly.
Pressing the witness. Objection. All the things you could object to. Right. Was it
Yeah.
labeled?
So Marcus, did you just make a blanket objection, or did you state the cause for objection?
Well, he
You
wouldn't let me
remember?
state the cause for the objection. Remember, they laughed, and then he went on to proceed and said, "Wait until it's your turn." Remember that, Steve?
Right. So the whole thing is everyone has the ability to object to anything that the court wants to say, imply, or move forward with.
Right.
The whole thing was when Marcus made an objection, the judge kind of like made a joke to kind of laugh it off, and everyone kind of laughed. But I was saying that it was very appreciative for me to be there and to be there for Marcus to let him know, like, bro, you didn't make
Come
an
on.
objection out of turn. You made an objection
Oh,
to
Timely.
preserve the record.
He made it timely,
I'm
like
sorry,
in the
brother.
moment. No, I get it. So basically, he just made a blanket objection, and upon appeal, he's a
It
litigant.
it really
It was
wasn't a
actually.
blanket
It was
objection.
actually
Upon the
objecting.
appellate, let me see if this is right. Upon the appellate, he would be able to say, "I was interrupted with my objection. I am
Exactly.
not a
Right.
bar
Yes.
attorney.
That's why I
The
was.
Father,
rest of the
That's why I was
objection
objecting.
is."
Lord,
I was
bless him,
objecting
please.
because I
Lord,
was
thank you.
interrupted.
Oh, man,
Okay, so
Lord,
he's
what
got
can
lots
I
of grounds
do,
to
my
keep that
Father?
in.
Man, thank you for this,
Right.
man, Lord. Thank you for
Perfect.
this, man, Father. Thank you for this, man, Lord. Thank you.
Yeah, this is good. This is amazing.
All
This is
right,
like hero stuff.
Marcus, you got any final words you want to state? I know Steve was
Sorry,
hitting
brother.
it. It's okay. No, you're good. I'm just closing it out on the recording anyway.
I
Anything?
will state this. Going through this has changed me tremendously because I have lost my mind going through this. I've lost a lot. I've lost a place where I stayed at. I've lost dogs. I've had to stay in hotels for months at a time. I've also sat in another jail because of this, because I was out on bond on another charge. When I caught this charge, I sat over there and I went through some racism over there in that jail. So like, when I got out, I could have fought that charge, but I just knew what was going on within the jails. So I got it knocked down to misdemeanors and I hauled ass. I ran with the probation and I fought this charge the entire time. Now, I was talking to some of my family members. They were just telling me to just take the time and just go to jail and just sign on the dotted line, basically. And looking at me crazy like, if you don't, they're gonna give you 11 years.
We ain't
Got my
Scared
do
to
that.
wife
We ain't do none of that
crying.
shit.
You know what's crazy?
Yeah,
That's fear, worry, and
yeah,
doubt. One of the
yeah,
three
yeah.
most biggest killers of faith, knowing, and projecting essentially what you want your future to be. Fear, worry, and doubt is the mind killer, bro. You gotta get rid of
Hold
that.
on, real quick. I know you're trying to close this out, Cam. I
Yeah.
do. I feel so bad if I didn't do this though.
What happened?
Marcus, keep it 100. Before we talk strategy, every time we jumped on the phone, like the last couple months, right, or a couple weeks, whatever. Before we even talk strategy, we gave glory and honor to the Most High.
Straight
The
up.
Most High.
Amen.
100,000%. Because I would be like, oh man, I got this paper. We should go ahead and file this, and we should do this, that, and the third. And I said, hold on, wait, hold on. We gotta stop. Let's give glory and honor to the Most High. You know what I'm saying? Before we even start talking strategy, You know what I'm saying? Like, nah. You know what I'm saying? We got to invite him into our atmosphere. But ultimately, what I wanted everybody to get from this is that, like, look, in the lower court is not where you're going to win. You know what I'm saying? Your lower court is your record audience. You know what I'm saying? Where you try to preserve the record. You're playing chess. If anything, I would encourage more people to know more rules of procedure. You know what I'm saying? To know when to apply constitutions, because just like what you were saying earlier, Cam, you can apply constitutional remedies and those formats, you know, say at a certain time.
Yeah.
But you want to know their rules, so when you start talking, you don't seem incompetent.
Right.
Don't go in with an attitude.
Right.
Go in with like, look, I'm here to go ahead and articulate and, you know, so to communicate positivity. Thank you, my love.
Yeah, because it's all about presenting what you. It's all about oral. Yeah, it's all about orally. It's all about orally being able to articulate what you're bringing forth in relation to the document that's set before the court, right? And to know how to move the court in that manner, and then call the other party to be responsible to respond, and in the way that they supposed to, anyways, according to the rules, bro. I mean, it's a great strategy. It's a great move. I congratulate both of you guys. You played brilliantly. I think the chess was just phenomenal here. It seems both of you would be great chess players. I would love to be able to come down to Florida here soon, bro, and play chess with both of you.
Hey, man, we're gonna invite you.
Okay, good.
Yes,
Hopefully we can get on the jet skis too and go through the glades.
We gotta do that, man. We
I'm
gotta do
trying
that.
to do that, bro. So
I wanna,
But you just came from an accident, Cam.
bro,
yeah.
bro.
That's a big no. That's a
Hey,
big no.
hey,
I'm just saying.
don't deny what guys already called forth. You did. Stop
Hey,
it.
but
Hey,
I want to
blessings
add this to my
coming.
closing though.
Okay.
Since I had this case, and I've been out on probation. Like I said, I've lost my mind. I was in fear for my life, still in fear of my life. I've been pulled over multiple times, and Cam, I will send you those videos. I'll send you those too, Steve, as well.
Yeah.
If anybody else wants videos, once Cam get my Discord back going again,
Yeah, we'll
just
pop back up.
message me, and I'll send them to you as well. I'll send you a copy. But they pulled me over, harassed me, jacked me up, violate my rights, no warrant to search, stop sticks all under the car, no narcotics being found, and they let me go. And these are the same officers that was in this case, as well as they would sit down the road from my house and stalk me and wait on me to leave, as well as a couple more agencies around the world, like Orlando. This was Leesburg, Lake County Sheriff's Department with this case, and Leesburg is within Lake County. They also pulled me over, harassed me as well, due to this case. So what I will tell you, yes, it's a scare tactic. I have learned a lot from it, and now I know how to operate in the field instead of within just the Constitution. You know, so like they said earlier, do not go in there talking Constitution. Stay within the procedures, and you want them to deny you. You know, because you know that your motion is right. It's sealed, signed, and ready for the DCA.
Yeah.
And you got the most high with you.
This case would have been a perfect case, guys, to like literally send a letter to the judge somewhere along the way, you know, near sort of after 2/3 of it had gone by and you had enough stuff, and just send a personal letter to the judge. I think that's allowed because they're the trier. If you've labeled them as such, and just say, Your Honor, this goes to claims after this. This goes to such and such. You already know that I preserved my errors.
Right.
Can you
So that's what I will say too.
are you allowed?
Okay, but wait, before we get into that, we're just going to say goodbye to the rest of the world right now for presenting this as far as YouTube is concerned and anywhere else you may view this. This operation, again, Wisedome, was on Saturday, April the 4th of 2026. We rolled through for almost about 4 hours as far as a presentation to the public, and we just want to let y'all know, like, yo, this is, again, one of the results and one of the things we live through. Like, we live as a connection to help each other through this world to get to the remedy that one seeks, and to give our experiences as one. And we all must remember that I am you and we are us and we are all a part of this great I am. And we growing, bro. And there is no stopping what we doing, because we will change our nation, bro. Y'all say goodbye to the rest of the world out there.
Bye.
You too.
Bye,
Take it
world.
Adios.
Doing Wisedome.
Bye-bye.
Don't forget, hit me up
Keep
on
your head up.
Discord.
Bye,
Hit Steve up.
YouTube.
Hit
You can
Cam
do
up.
that.